Just see what. Yes. Pardon to mention, Lordship. CRMC number 474 of 2025, which was listed before Lordship on Monday, last Monday. The FIR date, my Lord, is 23/6/2024. It has been noted instead of 2004, my Lords. The year, my Lords, it is.
Is it substantial? When that metal will come, you point out.
My Lords.
My lord,
If it is not substantial, if
My lords.
substantial,
first appeal from train accident. Train accident of 1996. Still, he has not paid a single pie.
FAO.
FAO.
Give
D card.
yes.
Notification order regarding bail, my lord. Kindly be taken a date, my lord.
Sorry.
Your lordship's modification order towards a bail, my lord. Modification, your lordship's modification for bail, my lord. Pray, my lord, tomorrow, my lord.
Memo. How will you give the memo? Somebody has to give the memo here.
My lord, my lord. Yes, my lord. I follow the VCP and it will also sort to your lordship.
Give the memo. Yes.
Beg your pardon, your lordship. Item number 81.
1 minute. Yes. Page by that.
Item number 1 to 7.
Pardon to mention, ma'am.
Up to date. I have missed it by one day of any development.
Release it, on the request of Mr. Chan. Release it. Yes.
Pardon, my lord. Item 3, my lord. I prefer an adjournment. Item 3.
3.
I prefer an adjournment, my lord.
On the request of counsel for the petitioner. Release the matter. Yes.
Item 8 to 18.
Item 16, my lord, preferred next week.
On the request of counsel for the petitioner.
Item 19 to 27. 28 to 39. 40 to 46. 47 to 52. 53 to 57.
Item 54, my lord. I prefer adjournment, my lord.
On the request of counsel for the petitioner. Yes.
58 to 62. 53 to 69. 70 to 75. 76 to 81.
Your lordship, 81. I pray adjournment. If
81.
your lordship be pleased to place this
Okay.
matter
On
on
the request of
commencing of
counsel for
17.
the petitioner.
Item 72. Item 72.
Yes.
Item 72. Can be adjourned.
Yes.
Item
Okay.
72. ma'am.
Adjourn. Yes. Okay.
Next week.
89. 90 to 99. 100 to 106.
My lord, item number 102, my lord. Date may be fixed, my lord, to 18th, my lord, and at 2 p.m. may be better because she will come from the remote place to appear before your lordship.
Settlement. Nothing. 2 o'clock. Today.
18th, my lord, 12.
18th.
18th.
Oh, 18th, 2 o'clock.
Oh, yes.
What are the offenses, by the way?
My lord, 498 already
Okay.
settled. My lord.
18th, 2 o'clock. Okay.
Item 2.
What is the matter?
That is my lord, final report submitted by the police. Thereafter, he is filed the complaint case, and the complaint case the protest petition, and in the protest petition.
Okay. Pass off.
Item 4.
Yes.
From the former 500, 501, this will be also.
Pass off. Okay.
Item 5.
5 hours.
Item 6.
Yes.
I have challenged the order of framing of charge. I have given the copy. Two charge sheet is submitted on 2 occasions. First, in the shape of preliminary charge sheet, that starts from page 13. The relevant part is where page. page 17 onwards. The relevant part is my page 18.
18, huh?
My like.
Yes.
It has been reflected that allegation of firing on part for some person. So, that's and here, Madam may see, in the first preliminary charge sheet, my name was not there. Other person's name was there. Now, this first charge sheet was submitted on 2019. Sorry, 2009, Madam.
Hmm.
7 years thereafter, in the year 2016, the second charge sheet was submitted. My humble submission before the Honorable Court, and my point of argument is that, is there any specific evidence which has come out during that particular period, which has entitled the concerned prosecution or which has constrained the prosecution to file charge
In the
sheet?
preliminary charge sheet, you are not.
No.
You are not.
My name was not at all whispered also. Subsequently, the final charge sheet, my name has been
Show
included.
me the final charge sheet.
That is, my lord, at page 20, 22 or not 23. Madam, may come to the second para, madam. Page 22, madam, second para. In this case, charge sheet number such and such, dated 2009, as I have submitted, madam, was submitted against 7 accused persons, namely such and such, under section such and such, madam. Then, my lord,
All the 7 accused persons were
Miles.
arrested and were sentenced to undergo imprisonment for life.
my lord,
Yes.
that part is there. And thereafter, my lord, that matter skip it
What
and the
trial of the rest of the accused persons in the custody, so.
cognizance taken against all the 9 accused persons in custody, part trial against accused persons, charge sheeted under such and such, submitted under such and such. All these 7 persons were convicted. Thereafter, my lord, next para.
Out of 5 accused.
Part trial rest the accused person, namely such and such, completed on 1/10/2013 by date number such and such in the court of additional session judge Kulbani. In this trial, accused such and such were convicted. Out of the 5 accused persons, accused Azad was arrested on 1/6/2011 at Noyagad, PS number such and absconder Sunil alias Sabyasachi Mahapatra was arrested on 18/7/2014 in such and such case number, with a prayer for issuing production warrant against the accused Azad and Sabyasachi Panda was made.
Oh, so you were absconding, therefore the charge sheet was
No,
not.
then my lord may have a glance to the preliminary charge sheet, my lord.
Investigation was open.
Yes. What is the material? My humble submission, yes. Of course, because the same way, my lord, they have submitted charge sheet showing the absconder to other persons, my lord, why not to me?
What is the material then?
Well,
In the supplementary charge sheet, you have said that he was absconding. It's all right. He was absconding. What is the material you have collected against him?
Next, my lord, CD is not there. But the fact remains, my lord, when the preliminary charge sheet, the investigation was kept open.
No, in the preliminary charge sheet, you are not whispering. These accused are involved, they are absconding, anything of that sort.
Further
And the
evidence-
final charge sheet, you say that he was absconding and he is involved.
Further evidence, I think, page 19.
That's what I'm asking. What are the evidence?
And I have to take criteria, because of the criteria I cannot, my lord, sir. But
I'll just
materials-
issue notice. Issue notice. Yes. See, you have said that 173(8) is open.
My lord.
But if once you file a final charge sheet, you have to say what are the material came against him. He was absconding, today I am filing charge sheet. That's all. Yes.
7. May I please. The case 307 and 326 matter has been settled on the last occasion I have said, and my lord have directed to take instruction about the injury and all these things. The state,
307.
yes,
What are the injuries? Show me.
Fracture of 2 legs, my lord.
that is there.
That's
Injury
also-
report was called for.
As per my current senior's version, my lord, he was expert.
No, after 1 year after, huh.
For that, the Rossi directed to take instruction, my lord. But, my lord, issued letter for no instruction. But he had written letter with no instruction.
Asha. Mr. General and Council for the Person seeks one more opportunity to obtain instruction in the present matter. Leave the matter on charge. Yes.
Item 8.
May please your lordship.
Yeah.
In compliance with the honorable court's direction, we are filing the jointer.
What are the offences?
Princess, my lord. As per BNS, my lord, the 126, 74, 78, then 351, 354.
Where are they?
Present in the
Court
case.
asked to appear them virtually.
Where are they?
Item eight.
What is the name of the petitioner?
Nihar
Niharanjan, okay. And informant, Prabhat,
Prabhat Chandra Saptate.
okay. Who is he? Prabhat,
It's the informant.
there is Nihar. Nihar, what are the allegations, sir?
126 clause 2 74 78 296 350.
Don't tell me the sections.
Allegations, my lord, को छोड़ा,
Malad, basically the prosecution story is that the petitioner went and verbally abused the informant's daughter as an outcome of which an FIR was registered. But subsequently, while availing the bail, the informant came and informant so motally suggested that he misconstrued the scenario as an offspring of the
Where is
child.
that? Where is that?
page 11 is there.
11?
Page 11 is there.
No, in the bail stage, where have we?
15 compromise.
15. Page 15. I know. That means since the opposite party number 2, number 4, charge sheet has been filed.
No.
The investigation in the present case is still going. At this stage, the petitioner was arrested. The petitioner was arrested, and he applied for grant of regular bail before the trial court. The trial court, by its order dated 7/11/2024, allowed the prayer and enlarged the petitioner on bail. At that stage, the informant had filed an affidavit stating that he has misconstrued the entire sequence of event and had filed the FIR. Relying upon the statement of the informant, the petitioner was enlarged on bail. When the matter stood thus, the petitioner had filed the representative to seeking quashing of the FIR on the ground of settlement. Next, the petitioner as well as the opposite party number 2 are present in the court through virtual mode and also being represented by their counsel. They have identified them and identified them. Both the petitioner and the opposite party have filed their separate copies of Aadhaar card, which are taken on record to establish their identity. Yeah, to establish their identity and taken on record. And the opposite party number 2 has filed an affidavit before this court dated 5/2/2025 in really stating agent. 227. 227. Petitioner has also filed anything? No. General counsel for the state submits that the informant at 2 different stages have reiterated the stand that the FIR was registered out of misunderstanding, and he has no grievance left against the petitioner. Both the petitioner and opposite party are representing the court, and they are reiterating the same stand. Hence, there is no legal impediment for the FIR. Yes. What?
My name has been reflected wrongly in the.
You give in writing your name will be.
Last time also I had given.
Now you give it. Yes. 9.
My lord, passing of the my lord criminal proceeding, I am challenging the cognizance order dated 18/9/20, my lord, annexure 2, page 15, offense my lord 376 2 FN of the IPC, and the matter also my lord already compromised. That is annexure 4, my lord. Charge sheet লেখা হবে, charge sheet লেখা হবে।
কপিটা দেবেন কোন
अच्छी देख लीजिए आप।
376
372 FN।
Compromise, then you have not included the informant. What kind of compromise?
My lords, I am appearing for the.
Maybe you are neither included nor you have to include. Promoter you can't like. How will you file wakalat now? For whom?
Yes, my lord.
For whom you will file?
Informant, my lords.
Informant is not a party.
Team, lords,
Then, or you take necessary steps. Then counsel for the petitioner an adjournment to include the informant and the victim in the present case is the respondent, let him do so within a week, leaves the map for it. Yes.
Short date will also. Short date will also.
Yes. Yes.
Great one. Here, my lord, I have challenged the order of the land court below, wherein he has rejected my application to expunge the name of the present petitioner from a petition under section 12 of the DB Act, my lord. From a petition under section 12 of the DB Act. The fact remains the present petitioner number 1 and 2, as I have specifically mentioned in para 6, they are none other than the PUC Sasu and Sasura. That means the husband of sister of the mother-in-law of the aggrieved lady, vis-a-vis the sister and the sister of the mother-in-law of the aggrieved lady. PUC and PUC Sasu, my lord. And they are residing at Bhubaneswar, whereas the entire cause of action arose at Sambalpur. Now,
Let us see the complaint.
I made out a party.
Where is the complaint?
Opposite party again. Sole opposite party.
You are in the complaint, DB case.
My lord.
You are
4, 5 and 6.
Respondent 5 and 6.
Sorry, my lord. 4 and 5. I'm sorry, my lord. 4 and 5.
4 and 5.
Again.
Jayanti Sodangi.
Jayanti and the other one is Dhananjay Sodangi.
Okay, let us see what are the allegations in the complaint.
She has made allegation against the usual manner. They were demanding that that's why some treatment was there, but no allegation against me. But because of the fact that I am related and not to my humble submission, yes, of course, had there been a
Mousa.
But Roach in Bhubaneswar. Kako chadna desh ke liye.
No record.
I will be active. I will issue notice.
Again.
Yes.
I've still missed cases there. So far the petitioner is concerned, madam, let them proceed. So far the petitioner is concerned.
Mousa, Mausi, Sasu,
Domestic relation that ho jayega. Even if they are not residing in the same house or they are not sharing.
You move application for them, let the petition. You move application at 205.
205 से appearance दरकार होने bail की appearance दरकार नहीं केवल खाली proceeding करियो मैं
application लगाओ for adjournment. I'll send it to mediation and finish it.
Yes, that will be better. As I said, in application we file, that will come.
Yes.
I don't know possible. Let's.
I have this application for passing in respect of petition number, present petitioner, my lord, arising out a complaint case, which was sent for investigation, case was registered. Petition is a student, my lord. The lordship turn to page 21, identity card. If complaint case has been filed, 498 along with other offences, my lord. So far as the page 16.
Who is he?
He is no way connected, my lord, but he has been implicated that page 16, your lordship, para 9.
Now, how is he related to the girl?
He was no way related, my lord, but he has been implicated since even the accused number 5, petition number is the accused number 5, my lord, in complaint case. Belmera Velu Gopal. And petition number 6 are spying on the complainant's brother by help of the accused number 7. He is a student, my lord. He has been implicated without any cause.
What are the allegations? Let us see first.
That is the allegation, my lord. Entire complaint case, that is the allegation, my lord.
Where
Page
is that?
16, para 9.
16. Para?
Somehow from the outer side, the complainant got information that the accused number 5 and accused number 6, uncle and aunt of the complainant, are helping the accused number 1 and his family separate the complainant and her husband, trying to create dispute between the complainant and her husband. Accused number 1. Even the accused number.
You are the accused number 5.
Yes, ma'am.
Even the accused number 5 and 6 are spying on the.
I am accused number 7, my lord. Accused number 7.
You are accused 7.
7. Brother, help of the accused number 7 and passing daily life information to accused number 1.
Belaram Akash.
Yes, my lord.
You are Belaram Akash.
Yes, my lord. He is a student. I have given the identity card.
Yes, what do you say?
We are abusing her in filthy languages.
App 498A.
at this stage, but.
I'll just see.
FIR.
See, this 498 is very
At this stage.
difficult. And he is neither related to the husband, nothing.
Investigation
He's,
is going on.
he's what you call allegation is he's instigating my husband and spying,
Well,
and he has to
at
face
this
it.
stage, that cannot be the ground for quashing. The investigation is there.
No, that's right. Technically, you are absolutely correct. But the fact remains that he is a 20-year-old boy. He has nothing to do with the family. They have a family dispute, wife and husband. Merely he is a friend of the husband, so therefore you implicate him.
Maybe investigation to continue.
Now the family, I can understand the family, Mosa, Mausi, Sasu, Sosro, everybody you are implicating. The outsider also you started implicating. 498. It's very. I can't say the investigation word. I'll issue notice.
Call for a report.
Yes.
You may be exonerated, I don't know.
He is a student, he is unable to study due to
But I'll
this,
just
my
issue
lord.
notice. I'll
Yes,
issue notice because
He
investigation.
just short date. my lord.
I'll just issue notice, just check it out. Exonerate this, he is nothing to do with. In the family fighting, let them fight. Issue notice, short date to this.
Obliged.
Status report to be filed
Yes.
by the state. Yes.
13.
Yes. Also.
14.
May I please? Kindly take Dr. Thieves. Because I have applied a certified copy and other relevant documents.
Okay. List it
Charge sheet.
on request. List it up.
Item 15.
It's prior to question of affair. Allegation is manner, according to the informant, the present petitioner kidnapped his daughter Malord. In the meantime, it's real fact of the case is Malord. Victim girl had love affairs with the present petitioner. She voluntarily left her home with the present petitioner Malord. Subsequently, she rescued and married to another person Malord.
What is the stage? What is the stage?
Stage is only affair that she has not written some.
The FIR is only registered.
Prayer for surrender. Surrender and release on bail.
365.
Married to another person, my lord. Photography.
I don't know whether, what is the age of this victim?
Victim is 20 years now.
20 years
At
now.
the stage of family, she is 18 years. Your lordship has the glass.
I don't know if the POXO is involved, I can't pass that order also.
365 is the POXO.
What 365 in the FIR? After investigation,
let
suppose
me
POXO
tell
is
you
there. How can I protect you?
And Anishru one had a glance, 18 years.
Huh?
Anishru one, your lordship has a glance.
Hmm.
Age 9. She is 18 years. Between them. His father wrote a fair man is 18 years. We only know about his marriage since last 2 years.
She is 18 years. She says that since last 2 years we had relationship. It goes down to 16 now.
160
Then POXO,
160 statement have a glance.
I read it. Therefore, I'm saying it. They will invoke POXO. I can't protect.
Surrender.
Let me tell you.
Bail marriage, she will face the trial.
No, you surrender, but I can't say that you shall be released on bail. Those kind of things will not happen. In
You will
POXO,
face the trial.
you have to face.
In any terms and conditions.
There are 482 at the initial stage of investigation. You are coming for questioning.
No court.
Why don't you
This is
understand?
not permission.
I can't do that because POXO is involved.
No court selection. Married to another person.
All these things you have to tell to the police. Police
You
file.
cannot apply for anticipatory
I don't know today what will be the offense. Today the offense is 365 only. And the statement of the girl, if you read, then POXO will be involved.
Really voluntarily let her share love affairs, my lord.
I know, but see the age of the girl.
Consent is there.
What to do?
He may apply for anticipatory permission.
But well, I have already
Not in this.
And rejected.
First of
It's already there. Where is the anticipatory wage?
not mention.
Huh? Where have you mentioned that?
I have not mentioned in the petition.
Then that itself be a ground for rejection. You went to anticipatory bail, got some order, you conceal it. Now you're asking for no coercive action. What is it?
It's not
Madam,
fair.
petitioner is seeking quashing of the FIR number. Allegation against the petitioner. Investigation in the present case is still going on. At this stage, I'm not inclined to interfere. Hence, the prisoner charges. Yes.
17.
Hello. The fact of the case is that the driver of the, the, the driver of the said vehicle violating rule 3.2 of the Odisha Minor Mineral Concession 2016. The unfortunately, the owner of the said vehicle did not give the challan, and for that reason, the range officer Nilagiri demanded challan. He did not show. So the said vehicle is seized, and the compounding petition also files before DFO Baleswar, but 12/2/2014 actually ସେଟା କିଣା ଯାଇଥିଲା ମାନେ 12 ବର୍ଷ ହେଇଗଲାଣି 4,95,000 ଟଙ୍କା ଫାଇନ ପକେଇ ଦେଇଛି ପିଟିସନ ହେଇଛି 4%.
Where is that order? What are you challenging, by the way?
Page 12.
Actually, answer one error, page 12.
You are seeking quashing of the criminal prosecution.
Compounding fine has been imposed.
Compound.
What are you asking? Just see the prayer. Be sure what are you asking for.
4,95,000.
Just see the prayer. You are seeking quashing of criminal proceeding 133 of 2024 arising out of so and so, so and so. What criminal prosecution?
Only more guy release for
You must tell me what are you seeking. I must understand what is the case is about. You are challenging which order? You are seeking quashing of the entire proceeding. You are arguing something else.
I'm release for
You are seeking quashing of the proceeding. Which proceeding? Which proceeding you are seeking quashing?
Actually, ଆମର ଯୋଉଟା ସ୍ଲିପ ମିଳିଥିଲା ସେ ସ୍ଲିପ ଟା ସେମାନେ ଦେଖେଇ ପାରିଲେନି ବୋଲି ପଛରେ ଦେଖିଲା ପରେ ସେ ଶୁଣିଲେନି.
Don't tell me the facts, sir. You simply tell me which proceeding you want quashing. Because your prayer is such. I think you are not prepared. You prepared. I'll put it next week. Huh? Tuesday wedding. Prepare and come.
Proceeding means madam release karo. Only release. How it's proceeding or doctor.
You asking quashing of the proceeding, and in that proceeding only some order is passed. Where 482 doesn't mean that you write whatever code you get.
Interim application only for to release.
You should challenge that order.
Yes, madam.
You have not challenged that order. That is the whole difficulty.
এই অর্ডারটা চ্যালেঞ্জ করে আনেশ্বর কেবল গোটিয়ে অর্ডর.
I'll simply issue notice. Let us see. He's not sure about what he.
No mention.
My lord, office order number 271. Seizure of one yellow color Lilian truck bearing registration number so and so, engine number so and so, seized during transmission of mineral without.
You are agreed by the compounding amount fixed.
Yes.
In the petition, you are saying something else. So I just issue notice. Please continue.
My lord,
Let us issue notice. Without that, I can't pass.
More use.
First of all, I can dismiss the petition right away because the petition, the way you have written, nobody can understand in there.
Interim order. I have also filed.
What could be the interim order? What could be the interim order? Compounding amount is fixed at 4,95,000. According to you, are agreed by that. I am issuing notice. Let us understand.
Yes.
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 Yes. Next.
18.
My lord, I'm in
You
virtual.
frame the petition properly, at least one can understand.
My lord, I'm in virtual. And
Yes.
my lord, this is that matter where, my lord, the summons were questioned, being outside the purview of the investigation. My lord, we have filed a response affidavit, additional affidavit, indicating that pretty much whatever we had, we have given without prejudice to our rights. We have given that. And and now, my lord, I just want to briefly state, my lord, the facts of the case. The fact of the case is that there was a source information to the CBI for the purposes of initiating a proceeding against one Chanchal Mukherjee, my lord, who was supposed to be the CCM or something of bridge and roof. That FIR was lodged, and my lord, they went and for the purpose of trapping him, my lord, taking the bribe from one of the persons who was supposed to be Maharana, to Maharana father, Maharana son. My lord, thereafter, my lord, they go to the particular office of Chanchal, and then say that that a blue-colored shirt wearing person comes out of the car, and then they drive towards Nandankan and some area from Forest Park into around that, my lord. Then they say that in the car, my lord, Chanchal gets into the car. My lord, that is
This is the case where the CBI is asking for certain documents.
Yes, yes. We have given most of them. I'm only saying further, my lord, I just want to indicate, my lord, the scope of against a particular office, a PSU. My lord, my lord, I was arrested. The arrest memo, my lord, is in the additional affidavit, my lord, dated 28/1/2005. May I take, my lords?
Last time I asked you to file the
arrest
document.
memo
Let us come to that. I understood it now. I
mine,
remember.
my lord,
Please
which is in the additional affidavit.
Copy of the same is also been supplied from
We have filed the documents. Whatever we have,
and
we have
all the
filed
documents as per this list, the list in the annexure, just come
Yes.
to page,
Yes.
page one series, annexure, one series.
Yes.
The document which you are
Yes.
seeking, all the documents are placed on record here.
My lord, the documents that are there with me, my lord, we have filed, and we have filed an additional
I told you to
affidavit
file an
saying
affidavit.
that these, my lord.
What are the documents available? Have you given
Yes,
those?
my lord,
Yeah.
we have filed the affidavit.
Let's come to that.
No, that's not been given.
Yes, yes.
Probably
Additional affidavit has been filed.
there is a communication gap. Those documents your lordship wanted to be produced here. We have not been able to file by your
A file, that is the only thing I.
Lordship may take it up for this limited purpose tomorrow. We will file.
The additional affidavit on
Those documents which you have provided to them, we file before the court here.
No, that's what I'm saying. See, by way of a summon, they are demanding some document.
That will file.
Through an authorized representative, you are challenging that. I said that whatever document you have, placed it on record, I will give it in finish.
So that will be concluded.
At least things will start moving.
We'll file it.
The reason I told you to file an affidavit.
There is a communication.
What are the documents? They are asking all the documents, place it on record.
Right, communication gap.
Let this matter.
Follow what I think.
They have filed an affidavit explaining what these documents are about.
But it is already on record, your lordship.
The explanation, they will do it. Why should you go?
We will file it.
You only they need the document for the purpose of investigation. There is an issue you don't want to give. I asked you to place on record so that at least the CBI should get those documents and they will go ahead with the investigation. If they find something, then we will see.
Your lordship, the documents, your lordships, at this stage, this is only the stage of the summons. He has already been arrested. Your lordship, this is a private thing between the CBI and the accused at this stage, your lordships. Lordships, at the summoning stage, your lordships, why should the court interfere in 482?
Then I am not interfering. I am just trying to help you out.
And your lordships, whatever
the all documents so that your investigation will go on.
We are all trying to help him out,
that the summoning order which you have given.
Yes.
seeking them to produce documents. All the documents, I'll ensure that all documents are given to you. That's all.
Yes, Your Lordship.
Not beyond that.
Yes, Your Lordship.
So that you can start proceeding with in accordance with the law.
But Your Lordship, their explanation that this document is not available, we will not give them. I am
That
not
will
the-
see. That will see. That document is not there. Whatever reference you want to draw. No problem. Whatever documents are there, at least you should get it, so that you can proceed further.
whatever
That's the
documents-
idea.
And whatever document is not there, Your Lordship, the police officer will continue investigation to find out how the.
You have right. Nobody can in the earth can stop you. Do it. Whatever. Let us, you give the documents only. Let us see. Give those documents. Let us sort it out so that we can. Yes.
Can I have a written submission?
What written submission? First of all, I should not interfere in the summoning stage. Somebody, the CBI has asked, issued a notice to you to authorize the representative to give the document. Why should I interfere?
Your Lordship, let's argue the matter. I'll reply now.
I am interfering in the investigation itself.
Lordship will interfere. There are two judgments. Lordship will interfere.
Don't go in so far. Give the document. Let us see. Find out.
We'll provide.
It may so happen that they may not require further document.
I will file it first. Let us see thereafter.
Let us have a practical approach to the entire issue. Give the document.
I only limited submission, subject to Lord. I will definitely comply with it.
Yes, yes.
Filing, but only one line submission. Lord, there are 99 Supreme Court and 99 Odisha and 2006 Supreme Court. Two judgments. Documents, summons for production of document must have a forbearance with the allegations in the FIR. There are two judgments. Unless it is connected to the allegation in the FIR, you cannot make a roguing inquiry. There are two judgments. And from
You say that these documents are irrelevant for the problem.
absolutely relevant.
So how does Your Lordship's order 172(3) of the CRPC?
Absolutely relevant. There are two judgments. I'll cite and from the facts of this case, I'll satisfy. Tomorrow,
Your Lordship, how
any documents, then we'll place
Get the document.
right. But let us first complete my lord's observation, then we'll come.
Get the document, whatever relevant.
Right, my lord,
According to you, at least
Not
give
get
those.
biased regards for your lordship's observation, comply with first, then we'll.
Whatever documents are at least you think relevant. See, you will decide what is relevant or not. Who can decide?
That's a pure question, debatable question.
How does the accused know that?
With referring to the judgment, Lord, will file those documents before my lords. We are protected in the hands of my lords, my lord. Let it come on Monday. Lord, your lordship documents will be on my lord's board. Then proceed further.
Okay, Monday. Okay, Monday.
Monday, Your Lordship, I'm not available, Your Lordships. Monday, I'm not, I have some problem, difficulty.
Monday, I will not conclude. Let them file the document first. Monday, let it come. Let it come. I'll accommodate you, Mr. Naik. Don't worry. I'll accommodate you. Let them file the document. I'll take preliminary on Monday and I'll accommodate you. I'll not pass any order on that day. Okay? Be sure. Monday, you file the document first. Only for the purpose of filing the documents.
That's because Your Lordship, last date of hearing when I was not present, they started arguing. They should not argue so that I can counter.
No. I'll not entertain. Don't worry.
But argue, have you, Mr. Naik?
He has passed an injunction order against you.
You are passing an injunction. Headline 1 is not applicable here.
And is Mr. Naik available, my lord?
Headline 1 is not available here.
You file the document with.
This is BNS and BNSS code. CPC is not applicable.
The 498, 494 might have a settled between the parties. I pray Malan to fix any date next week. So that things can be. I made the informative party.
498.
Yeah, 490, 494.
Yeah, petitioner is the husband and mother-in-law.
Settled. They've settled.
I guess.
Settlement.
So then I'll issue notice.
Yes.
Issue notice. They've settled. Issue notice. Huh? Next week, when can you bring them?
Any day, Malan.
You tell them they have to come, no?
Thursday or Friday, Malan.
Huh?
Thursday or Friday. Next week.
Huh? Okay, 2 o'clock. 2 o'clock. Because the pass and everything,
yes,
they
yes,
do it. 2 o'clock.
That is doing date 14.
20.
My lord, in this case, my lord, the opposite party wife had filed a miscase, MC case, maintenance case, where the MC case number 32 of 21 for enhance. That is annexure 1 plus 8, my lord.
Yes.
For enhancement of monthly maintenance allowance from 2,000 for the petitioner 1 to 8,500 and 1,000 to 4,000.
What are you doing?
Petition 2.
What are you doing?
My lord, I think.
The teacher.
No, from the
Teacher.
my lord, from the date of order, that is Order portion, page 11, my lord.
Mhm.
Deducted 10,000 per month. As for direction of this law and code below, the 10,000 deducted from my salary regularly till date. Again, my lord, what happened? The opposite party wife again filed a MC case by the MC number 7/24. He has stated that some area amounts are there that same may be deducted. That is annexure 3 series, my lord. Annexure 3 series is
Yes.
20 to 30. Page 20.
What do you want now?
What happened, my lord? She has at the time of filing the second MC, that is 7/24. The age of the opposite party number 2, 19 years, 2 months. Already she is measured, my lord. The petitioner wife suppressed the age of the OP number 2.
Forget it.
Number 1.
Your daughter?
Yes, my lord. Number 1. Again, what happened, my lord?
I'll not give.
Yes, what happened, my lord?
Is your daughter
Yes, my lord.
19-year-old girl?
I am not Jason, but what happened, my lord? She has stated that from 9/5/2023 to 8/2/2024, 9 months, 90,000 area maintenance is there.
Do you want me to?
No, what happened, my lord? From 9/5/2023 to 8/2/2024, already 1,40,000 already deducted from my salary. Excess 50,000 already excess deducted.
Have you told all these things?
Yes, sir. I annexed my salary
Have
statement.
you told all these things to before trial court?
Yes, my lord. Yes, my lord.
What is the order?
That is annexure, input order, my lord.
Show me the order.
Annexure. Annexure 4, my lord. Page 31.
This is what you are challenging here.
Page 31, my lord. Input order, my lord. Page 35.
35.
35.
Okay.
5/9/2024 order, my lord.
Read it.
Yes, my lord.
Yes.
This order arises out of a petition dated 21/24 under section 125(3) CRPC filed by the petition with the prayer for maintenance from the opposite party or from the OP, copy served on the other side. The petition's case is just can be extracted as follows. On dated 8/2021 in MC case number 32/21, this court had directed the opposite party to pay 10,000 per month, 4,000 for the petition.
How much you have paid extra? 50,000.
No, my lord. Extra already, my lord. 78,000.
So then you have paid to your wife and husband.
No, my lord. My lord. Already excess amount of deducted from my salary. A measure his salary, my lord. She is not entitled, my lord.
She is 19-year-old girl.
19 years.
Then?
Salary. Measure, my lord. She is already.
Will she not pursue the study?
Yes.
Who will bear the expenses?
Father. I have no objection. From the date of order.
50,000 rupees you are coming.
No, my lord. What happened? From the
Not paid to anyone else. Your wife and your daughter who is 19-year-old.
My lord. From the date of order, 10,000 already deducted from my salary.
Hide behind the your technicality. You have to pay just 10,000 rupees.
Already deducted from my salary.
That's right, but 10,000 rupees you are paying for survival and study up for the girl and both your wife and daughter. 10,000 is very meager amount. You are a teacher.
Yes, my lord.
You pay it. I will not.
But excess amount of documents is already deducted from my salary. Regularly deducted from my salary. Current amount I have no objection. Current amount 10,000 I have no objection. But the excess 90,000 she has claimed. But excess documents is already deducted from my salary.
Issue notice to opposite party. Written will also subject to petitioner continuously paying the regular maintenance without fee. Yes.
Well, I have mistress, my lord.
I will not say. I have
Current deducted I have no objection. But the area deducted.
issue notice.
Salary deducted.
Maintenance thing I
Current 10,000 I have no objection.
I am not going to stay.
No. Current 10,000.
Maintenance 50,000 rupees you have paid to your daughter who is 19-year-old and you want stay of that.
No. 10,000 objection.
Otherwise I'll dismiss.
No, 10,000 I have no objection. 10,000 currently I have no
objection. I will arrange it. 19-year-old girl, she will study. What is it she doing?
No, she has filed the.
She is doing.
She has filed the case against me.
Your daughter is doing.
She's prosecuting study, my lord. Prosecuting study.
You also don't know.
I have no instruction, my lord.
This is the level of your affection to your daughter. Okay, next.
31.
I have issued notice. We keep on paying. Let us see.
My lord, deduct is put it up.
Let us-
Again deducted.
Yes.
In salary statement, I have mentioned my salary statement.
See, your teacher is 50,000 rupees here and there. How does it make difference?
Well, Sabuja 50,000 will pause. Deduction like 50,000.
How much is there?
Private school teacher, my lord. Private school teacher. Father, mother, my actually more.
Tuition पढ़ान्तु बारे. जियो को पढ़े.
मैं सर हम salary statement हम.
बारे tuition पढ़ेगी कमान्तु और जियो दियो. What do you think?
Kind of last statement.
You have determined that. You have determined that your petition should be dismissed.
No.
Have issued notice. Let it be.
No. 32,372 last ହେଇଥିଲା 29 ଅଗଷ୍ଟ 2024 ରେ 32,000
40,000, 50,000 you are giving to your daughter and
objection ମାଇଲର ନାହିଁ ଯୋଉ 10,000 କଣ୍ଟିନ୍ୟୁ ହଉଛି ସେଟା ମୁଁ ନାହିଁ କରୁନି ମାଇଲର କିନ୍ତୁ ଏକ୍ସଟ୍ରା ଡିଡକ୍ସନ ହେଇଯାଉଛି ସାଲାରୀ
I passed the order.
ସେଇଟାକୁ ମାଇଲର ଆଟଲିଷ୍ଟ
Continue paying.
ଏରିଅଟା ମାଇଲର ଆଟଲିଷ୍ଟ ଷ୍ଟେ କରାଯାଉ ଏଇଟା କଣ୍ଟିନ୍ୟୁ ହଉ ଆଇ ହାଭ୍ नो ଅବଜେକ୍ସନ ଏରିଅଟା ଷ୍ଟେ କରାଯାଉ ମାଇଲର
Next slide.
Order of cognizance.
You have done very well, but what to do? You are holding a bad brief.
Operation successful.
ସେଇଟା ଆଜ୍ଞା ଷ୍ଟେ
Many a time happens. You hold a bad brief for.
No, current ପାଇଁ I have no objection କି ସେଇଟା କଣ୍ଟିନ୍ୟୁ ହେଲା ଆଜ୍ଞା ମୁଁ ଚଳିବି କେମିତି
You
ମୋର
have a very good persuasive capacity, but what to do? We'll see. I'll just give a short date and
ପ୍ରାଇମେରୀ ସ୍କୁଲ ଟିଚର 32 ଜଣ ପର୍ଯ୍ୟନ୍ତ ଛୁଆ ପିଲା ବି ଅଛନ୍ତି ପୁଣି
we'll see. Yes.
Here our order of cognizance under challenge and petition before my lord is the mother-in-law. Old aged mother-in-law. And may see the affair. It starts from page 9. The first line she has said that I am such and such 31 should move a formal complaint against my husband such and such agent such and such. So she has made the complaint against the husband. And
Where is the charge sheet?
charge sheet, my lord, a small one, my lord, 2-3 pages. And
Challenging cognizance order not filed charge sheet. In the 498 case.
and the allegation she has made the telephonically.
When you file charge sheet, I am issuing notice. Huh?
My lord.
Oh, you have not implemented informant also. What to do?
I will,
What kind of petition?
No, my lord may say I'll file the that other statement.
You at least implement the informant
In course of
498 case.
in course of the day, I'll file the cost address.
You do one thing. I'll put it after 1 week. Implement the
Complainant.
complainant. It is a 498 case. Complainant has to be there and file the charge sheet. I'll issue notice. You'll see. Next week. Look at it. Huh?
Next week then.
Next week. Yes.
22.
Yes.
Lord, I appear for the petitioner in this matter.
Yes.
Lord, this is a peculiar case. Lord, one is arising out of the vigilance matter. The other one is arising out of the predicate offense where an ECIR has been registered. Lord, the facts of the matter are, your lordships will be aware in Orissa mining case, Lord, 146 mining leases were found to be deficient in various ways.
Yes.
Lord, a prayer was made before the Supreme Court to direct CBI investigation and to give criminal liability action. Supreme Court declined that, but said you recover the amounts from this particular mine owners. Lord, in Orissa, out of 146 persons, only one company was chosen. That is, Lord, the petitioner company, against whom, Lord, only that, because BK Mohanty, my vendor, earlier vendor, predecessor's vendor, because now the company has also changed hands. The company is an accused who is to purchase this ore from Mr. BK Mohanty. BK Mohanty was chosen, and therefore, Lord, the company to whom the ore was sold were prosecuted. Now, this prosecution was filed 9 years back. In between, the company changed its hands. There is an attachment passed because of which the company has become defunct. So, my lord, today I have come before your lordships. 9 years have passed. No charges have been framed. Nothing has been done. And this prosecution squarely falls within clause 7 of Bhajanlal's judgment, where it is a pick and choose case, most unreasonable case where you have gone only against one person, leaving out others, then, Lord, it's a fit case for 482 exercise of jurisdiction. Today, Lord, therefore, I file this particular petition. There are various other points also, Lord, because this basically revolves on the fact that the whole prosecution.
Here, are you referring to common cause?
No, common cause judgment, where the judgment was delivered by the Supreme Court. There the prayer was made for Lord prosecution. Supreme Court declined that, did not even refer it to CBI. Thereafter, Lord Justice Shah Committee was set up.
Yes.
Justice Shah Committee. Justice Shah Committee said that 146 mines in Orissa have done illegal mining or deficient in certain ways. Now, Lord, one of the mine owners was Mr. B.K. Mohanty, who was a lessee.
No, 146 was companies were involved. Prosecution is launched against all of them.
No, only one. Only one mining lessee, B.K. Mohanty, was picked up, and against him prosecution was lodged.
Issue notice, let us see. Issue
Lord,
notice.
asking for stay of
Issue notice, we will see. We will examine it.
Lord, we are
Issue
asking stay of the prosecution because otherwise, Lord.
And you say that 9 years nothing has happened.
No,
What
9 years
happened?
nothing has happened. 9 years nothing has happened. If your lordships are giving a because
Already been examined. Page 321.
No, insofar as this company is concerned.
Because there was a case.
Their own government, page 32 of can see.
No, my learned senior is referring to ED case, first case, my lord. It's not vigilance.
No, that is a different.
My learned senior is submitting with regard to 9 years
Vigilance
with
case is
regard to ED
subsequent.
case.
He is not talking about vigilance case.
Vigilance case is second case.
Oh, let him move application for it. Okay. Okay.
Lord, your lordship may issue notice on the interim relief also. Lord.
Yes, and you move an application before trial court for adjournment, that will be ended.
Lordship, Lord, stay of proceedings.
21.
Yes.
321.
Yes.
320, madam. It started from 320.
321.
320. It started from 320. Para V.
Yes.
320. In view of above. This is the
320.
320.
Okay.
This is the complaint petition.
Yeah.
In view of the above, provisional attachment order dated 21/5/15 was issued under section 51 of the PLA in respect of the movable and immovable properties. The said attachment order is pending confirmation by the London Adjudicating Authority. The party had referred 4 writ applications before the Honorable High Court order. The Honorable High Court had ordered dated 18/8/2015 as directed stay in further proceeding of our Adjudicating Authority until its exact hearing, and has directed that the attachment order shall continue directing the.
Where is that order? Where is that order? Where is that order? You have that order.
And this case was disposed of.
Very, Mr. Natkani, where is that order referring to that page 320? You referred to some order.
That has been vacated and final order has been passed, giving opportunity to appear before the adjourned.
Place that order. If so, there shouldn't be any overlapping.
No, Lord, I'll tell your lordships. What is referring to is the attachment order, which attachment order has been confirmed by the adjudicating authority. Against that confirmation of the adjudicating authority, we have gone to the tribunal.
You file response to this.
Yes,
It's
yes.
very complicated fact. Yes.
Vigilance case is concerned, that will not be.
Vigilance case, which one?
That's detail number 5.
The second one, my lord, CRLMC 506.
Vigilance case is, there is no interim order. So now the case is going.
I just issue notice, will see? Huh? Okay. In both the cases, I will issue
Simply,
notice.
only simply.
Lordship, please oblige.
Okay. Next.
Oblige.
23.
May I please your lordship? Lord, am I audible? My lord, in this case, it's res ipsa liquita at page 46 of the charge sheet. They clearly say, my lord, the licenses were extended because no bids were received and due process was followed. So actually,
What are you seeking? What are you seeking here?
my lord, I'm only today seeking, in the main prayer is seeking quashing. In the interim, my lord, stay of proceedings because the charge sheet itself shows no ingredient made out and no road. Not that I am saying it. Page, please have page 46.
46.
Yes, my lord.
Yes.
Yes, my lord, if my lord kindly sees 16.16,
Yes.
about 10 lines from the top where it starts thereafter. Thereafter, license extension orders were passed in favor of Orissa Stevedores. Thus, in this way, the license for installation, operation, and maintenance of the capacity for a 3-year period was given to 3 companies, including Orissa Stevedores. Moreover, while granting extension, these relaxations were given in the terms and conditions which were applicable while floating the fresh tender. Now, my lord, the entire case was that these 3 things, the entire process had been followed because no bid was received, which you will get at para 16.14 at page 45.
Yes.
Investigation has revealed that the license period of the 3 companies was expiring. Therefore, after due approval of the chairman, e-tender notice was published. However, no bid was received against the said tender. Therefore, the tender was discharged with the approval of the chairman. Investigation revealed no bid was received. So, my lord, because no bid was received, the licenses of all 3 companies were extended. So there's no question of payment of any type because of that. Next, my lord, at page 42 on the top, the telephone transcript, my lord, the CBI court itself at page 241 says, my lord, that no recording of voice sample is to be permitted. No role is ascribed to me. No evidence against me. No ingredient made out, which you will now see at page 42, para 16.4.
Yes.
I can't show the negative, but please take it that my name, that is the petitioner's name, Charchit Mishra, my lord, is singularly missing in 16.4 and 16.5. And the CBI court, my lord, at page 241 says that I will not permit recording of voice samples. It is illegal. Everything happened prior to the FIR. So today, as the charge sheet stands, my lord, there is no factual foundation. There is no ingredient which is made out. There is no link of the petitioner in the entire chain.
Are you really agreed by the voice sampling issue or the quashing of the entire prosecution?
My lord, quashing of the entire prosecution because the 2 allegations made against me strengthen the charge sheet itself shows there's nothing. I'm not saying it. Now page 45, 46 and 42, which is their own charge sheet, itself shows that there could be no question. So I'm not, quote unquote, no role, no link in the chain of causation. Extension was granted because no bids were received of all companies. And at
all 3 companies.
Yes, and my lord, the highest case was that I was aware because of that conversation. And that conversation, my lord, the CBI court says, I will not allow, my lord, recording of voice samples because it was illegal. So today, strength the charge sheet, my lord, continuation of proceeding will be a complete abuse of process. So like wine, my case has improved with the charge sheet. They themselves have arrived at the fact, my lord, that there is nothing at all to prove any charge.
Yes, Mr. Naik, what do you say?
Your Lordship, yesterday only I received the copy. I need time for instructions in the matter.
Okay, I'll issue notice.
Yes, my lord, your lordship may only say stay of further proceedings subject to their filing the reply, because I have shown on the basis of their charge sheet. Well, he can't improve his charge sheet. He can take time to study.
But your
yes, issue notice. He'll move application for adjournment. Yes. If I'll reply, I'll put it after 2 weeks.
My I-412 is of stay of proceedings. Your lordships, on the basis of what
you
I
move
have
application before trial court. Let us see what happens.
Then they should make a statement that they'll take a adjournment in the trial court.
Yes. Yes.
Let me make one request. Since I have shown it on the basis of the charge sheet, your lordship may simply say that it will not be taken up till the next date of hearing. That will suffice for the moment. That will balance the interest of justice. It will not make any difference. I have shown from the charge sheet that it can't get higher. Their whole case is to be based on the charge sheet. So your lordship may say,
Yes.
till the next date
Yes,
of
Mr.
hearing,
Naik,
the matter will not be taken up before the trial court.
Your Lordship, under 19(3)(3) of the PC Act, proceedings under the Prevention of Corruption Act cannot be stayed. Therefore, no order should be passed directly or indirectly.
No, I know. I am aware of that. I'll
And
let
number
him
two,
move
your
application.
and number two, your
Application
Lordship,
for adjournment.
your
Okay,
Lordship,
solved.
your Lordship, the second matter which was challenged, which your Lordship was hearing, Mr. Tanvir was arguing, that matter, your Lordship, is listed on 6/3/2024-25. So both the matters may be listed on the same date, your
Okay, on
Lordship.
6/3. Yes, both the
So that,
matters.
yes.
Yes.
And my
6/3.
lord, your lordship may say we can move an application for adjournment, which the
Yes.
trial court will consider till the next.
Yes. Yes.
Your
The
lordship
matter
may
should be tagged also, your Lordships.
that in
Yes,
the
yes.
order.
Yes.
Your lordship,
Great.
both matters may be tagged.
I have done it. I have done it. Yes.
I am so great. Give me.
Next. 24.
24.
24. 24.
May I please, my lordship? My lordship, here the victim's brother claims that he might have fired 2 round firing, and on that basis, FIR has been registered, my lordship. And there is no witness, no eyewitness, because he has killed my father long back and already completed 12 years judicial custody.
How many cases you have, basically? How many cases is filed against you, and how many cases you have filed against?
No, not a counter case. Only one case has been done.
Only one case.
Yes, my lordship.
In this case, what happened, the present petitioner earlier approached before this honorable court for 38 bail application lordship. That bail application, this coordinate bench has allowed the present petitioner to first surrender first or second hour lordship. That order was passed on 13/1/2025. My learned friend is not.
So sorry, I'm so sorry that I thought that you are
No,
personal.
that's not
It's not personal.
No, no,
Feeling as a lawyer. Okay, I'm so sorry. I'm so sorry because you have
Yes, my
couple of personal cases, so I got confused.
The
Yes.
present petitioner earlier approached the honorable court for under 438 CRPC for bail.
What are you asking, madam, here?
Seeking for passment.
For passing of the FIR, my lordship.
The learned friend before, as per the High Court rules, not been disclosed the earlier bail application filed by the present petitioner.
You should have done it.
And
Already-
the
no, no.
FIR is initial speech, your lordship, that kind glance of the FIR of the year 2011, 2024. November 2024 FIR.
Investigation is going on.
Speech
First
was
of all.
taken.
Investigation is
And
going
second
on.
is you have approached this court by filing some bail application which has been rejected, you are not disclosed. These are two grounds
No, not,
sufficient
it
to
has been
dismiss.
given as to surrender and
Whatever, you should disclose it.
But the High Court rules have been.
Suppose I pass some order will contrary to that order.
no, no,
or some.
my lordship, the false case has been
That's
posted.
right,
There is
madam,
no
but-
witness, my
but the
lordship.
minimum requirement is you should disclose when you have that is the rule now.
No, I in bail application it should be I mentioned, so for
No,
that
my
only in
God.
passing I have not
Whenever
mentioned
you
it.
come to the court, then you must come with clean hands. Then only you can get relief. I just adjourn it, disclose it. Okay.
Oh.
Why to? I just simply adjourn it. I am simply adjourning it after 2 weeks. You disclose it, do what? Then I'll examine. By that time, you just see what is the stage investigation.
My lordship, the interim can be.
No entry. No
Okay.
entry. Because you have, I can understand if you have disclosed the order, I can think of doing something. You went to the another court, got some order, you are not disclosing that.
Okay, my
And
lordship.
that is in a deliberate attempt on your part, so that you can get some interim order. That's not fair.
Okay, my
You do
lordship.
it.
Can be adjourned.
You disclose it on, you disclose it, thereafter I'll see what can be done.
Okay. Okay.
Yes.
25.
May I please, your lordship, I am on CC, my lord. Am I audible, my lord?
Yes,
I am on VC. Am I audible, my lord?
yes, I can hear you.
Lord, this is the matter wherein your lordship, on the last day, Mr. Nayak was unwell, so adjournment was sought on his behalf. My lord, in this particular matter, I just tell you the facts in a very brief manner. My lord, this actually matter, 15 lakhs was taken from the custody of the particular petitioner while he was taken into custody by the CBI on 26/9/2022, my lord. And thereafter, my lord, we have filed an application for release under 451 to 457 of the CRPC, citing all the judgments, my lord. And those judgments are before your lordship, my lord. Sundar Lal Bhai Ambal Lal Desai versus the state of Gujarat, along with Manjit Singh. My lord,
Yes.
wherein the honorable court had been very clear and unequivocal that the particular cash amount and other things should be released upon furnishing a bond, my lord, and onerous conditions may not please be imposed. In that event, my lord, Mr. Nayak has vehemently opposed.
No, I'll argue now.
Stated, my lord, just a minute, Mr. Nayak, only a minute. Thereafter, you will submit. I have completed my submissions on the
Yes,
last day. Wherein Mr. Nayak has stated that this culminates out of a special case of the special bench of Honorable Supreme Court in Subrata Chattoraj, wherein their lordships have stated that this should not be released. This is on record, my lord. And thereafter he says, no, about the money trail. My lord, presumption of innocence is in favor of the petitioner. The entire.
Let us come to the impugn order. Let us come to the impugn order, first of all.
This is the impugned order at page 25, my lord.
Page?
25, my lord.
Yes.
Starting from page 25, my lord. My lord, kindly sees. Page 28 and 29, my lord. 28, my lord. The last paragraph, my lord, it is further alleged. My lord gets it?
Yes, yes, I'm there.
It is further alleged that the petitioner and the said Uttam Munshi have created fake documents to establish and run their Ponzi scheme. My lord, I pause here for a moment. He is a consultant.
Yes, Mr. Naik, let them furnish property security, let them take the cash.
Your lordships, the judgment which he is citing, your lordships, let us go through those judgments, your lordships. He has never said that which paragraph of the judgment.
Let us forget about this judgment. Let them let him furnish the property security, let the take the money.
Suppose your lordship now 15 lakhs have been recovered. Suppose 100 crores would have been recovered, your lordship would have asked him to take it back. Your lordship may kindly come to page 14 for a moment. In case where
14.
such articles, your lordships, page 14 of the judgment which he is citing.
Which judgment?
Sundar Bhai Ambalal Desai, your lordships.
Sundar Bhai, okay.
Yes. Let me read those judgments, your lordship. These are proceeds of the crime, your lordships. And he is not the rightful owner of the property.
Yes.
The rightful owner of the property, your lordships, are the taxpayers, the investors, the innocent investors. Your lordship may kindly come to page 14.
Yes.
He has never said that it will be given to him. In case such articles are not handed over.
14, huh? 1-4?
Yes. We can start with para 11, in fact, your lordships. Para 11 says that.
Where is 14?
There is no page 14, my lord.
Para 14, no page 14. Yes, lordship.
No, 14 paragraph, where is it?
I'm giving the
judgment dated 1/10/2000.
No, you have given, but the para 14 is conspicuously missing from here. After para 12, 13, part of 13, directly 19.
Then page 289, my lord.
Give the proper one.
He has not given, I think.
No, he has given, but para 14, he knows that you will rely upon para 14. So the para 14 is left. Yes, this para 14.
Para 14 says that, your lordships, in case where articles are not handed over. In case articles are not handed over.
Either to the complainant, yes, or to the person from whom. Yes.
Your lordship, in case.
Yes, go ahead, I can hear you.
In case where such articles are not handed over, either to the complainant or to the person from whom such articles are seized, or to the claimant, then the court may direct the such articles be kept in bank lockers. Let it be kept in bank lockers, your lordships.
Yes.
That is his judgment only. And second thing is, the lordship is not written that it has to be given to the person from where it is seized.
In case it is not given, it is it can be
given to the complainant also, your lordships.
In case where the articles are not, we are not talking about the articles. We are talking about the cash. Here I think some.
Same thing, your lordships. Para 11 is applicable. Para 11 and 12 is your lordship may kindly see para 11, valuable articles and currency notes. The principle is applicable for both valuable articles and currency notes, your lordships.
Yes.
Page paragraph 8.
11, huh? With regard to the valuable articles such as gold, silver ornament, articles studded with the precious stones.
Yes.
And it is that use of such articles. So these are regarding articles.
The idea was that anything which has a natural decay, it never says that it has to be given to the person from where it is seized. It has to be given to the complainant also, your lordships. So
those things are regarding the articles. Articles may be required for the purpose of producing in the court and all. It is a cash of 15 lakhs.
And currency notes is also given.
Will you give bank guarantee for that?
10 lakhs bank guarantee, let him give.
Bank guarantee is not possible. We'll give the security, my lord. My lord, one thing is that
50% bank guarantee, 50% property security. Give it, finish it.
My lord, kindly comes to one thing.
50% bank guarantee, 50% both balancing act.
My lord, kindly says that we'll give the property guarantee. We'll go giving the property there.
Lordship may kindly come to last date of hearing, your lordships had asked me to see the Subrat Chhatoraj judgment.
Yes.
Your lordship may kindly see para 30 of Subrat Chhatoraj judgment.
Which judgment?
Subrat Chaturaj, para 30. Last date of hearing, your lordships had scolded me. I had no judgment.
Yes.
Your lordships, para 30 of Subrat Chaturaj judgment, your lordships.
30.
Para 30.
Yes.
30.
Investigation
Read it.
conducted suggests that collection of money from the depositors were neither legally permissible, nor were such collection deposit invested in any meaningful business activity that could generate high returns promised to the depositors. Now, Supreme Court, your lordships, was prima facie of the view that these all are illegal collections. Now, charge sheet has been filed, your lordships. In charge sheet, it is clearly and categorically stated that more than 5 crores he has misappropriated. Now, the magistrate has also seen the documents and perused the record and said that they are involved in, your lordships, prima facie in these kind of activities. This judgment, your lordship, is saying that the money has to be returned to the complainant. If your lordship will see para 14, the rightful owner, the court has to exercise the discretion or the jurisdiction that whom prima facie the money should belong to. And the word is may in 451. This money belongs to the complainant, your lordships, not to the accused. So either it has to be given to the complainant as per the judgment or kept in bank locker. Lordship may see, because the heading of the other
No, it
judgment
is
says
recovered from his office.
yes, it is recovered from his office. Let it be kept in bank locker, your lordships, in safe custody. The idea is that it should not be decayed.
The cash will not be decayed, don't worry. It will be invested and learn money.
Your lordship, how can the proceeds of the crime be given to the accused during the pendency of the proceedings?
Lord.
See, that is the reason I want that it should be secure, so that if it is determined that it is a procedure of crime after the trial, he should be in a position to give it back or recover it.
Tomorrow, citing this judgment from Pradeep Sethi's house, so many cash was recovered. So many chit fund accused all over India are there. Somebody will claim 50 crores, somebody will claim 100 crores. This is a small amount, therefore he's claiming.
You are absolutely right, but that is the reason I'm saying 50% bank guarantee, 50% property
Suppose
security.
tomorrow, your lordship, Pradeep Sethi will come and say that 50 crores is seized from my house, you kindly return it back to me, citing this judgment. Let it be kept in bank locker, your lordships.
You are right, you are right, absolutely. You are right. What is the stage of the trial?
Appearance of the other co-accused.
Yes.
Kindly comes to paragraph 8, Milord.
Paragraph 8 of what? Judgment?
Yes, Milord. Not Chattaraj, Milord. That Sundar Bhai Ambalal Desai, Milord.
Yes, para 8.
Para 8. Milord, kindly comes to page 288. There is a break of page and then page 288. In the same page, Milord. And here is the object and scheme of various provision of the code appear to be that where the property which has been subject matter of an offense is seized by the police, it ought not be retained in the custody of the court or police for any longer time what is absolutely necessary. Milord, here it is money. I give the guarantee, presumption of innocence is in my favor, Milord. How Mr. Shastak Nayak is saying that it is a proceed of crime. I am an innocent person like anybody. I have been only implicated by them. And my presumption of innocence is there, and Honorable Supreme Court has granted me bail upon their vehement objection, Milord. And that is on record, Milord.
The judgment is also that it can be given to the complainant, your lordships.
Manjit Singh, Milord. Another judgment, Milord, kindly comes to Manjit Singh. Milord gets Manjit Singh. Milord, para 65.
65 of what?
Manjit Singh. That is 2014 SCC Online, Delhi 4652. Wherein all the judgments of the Honorable Supreme Court and the other courts have been taken into account and consideration, Milord. Kindly seize, my lord.
65, yes, para 65.
The currency note seized by the police may be released to the person who, in the opinion of the court, is lawfully entitled to claim after preparing detailed panchnama of the currency notes with their numbers or denomination, taking photographs of the currency notes, and taking a security bond, my lord.
That means, your lordship, who, in the opinion of the court, is the
Milord, I would beg to state one thing. I would seek permission of Mr. Nayak for a moment. Milord, kindly see, the presumption of innocence is in my favor. I have not faced the trial. This amount has been taken after 12 years from the custody. I would have kept the 12 years in the custody of my office, and it is my mother's treatment money, Milord. And only upon making submissions that yes, this money belongs to the proceeds of crime, where he was only a consultant, Milord. And there is every possibility we come out fair in the trial. Unless one is convicted, my lord, the court takes him as an innocent person. Only saying by way of making submissions that proceeds of crime and proceeds of crime will not suffice the purpose for anything. My lord, my humble and respectful submission, that person is a educated person, his mother's money, his own money, all has been accounted for, and the money, if it is taken, we are ready to give any bond, lordship, property bond from the local surety, whatever it is. My lord, in passport also they have objected, in bail they have objected for the gold ornaments, all has been released. Now they are on the money.
Your Lordship, the charge sheet
I give
reveals
it
that.
to your lordship because, my lord, I have given.
Your Lordship, the charge sheet reveals that the educated person is a.
Yes, Mr. Sinha, it's all right now, Mr. Naik.
Yes, Your Lordship, the charge sheet reveals that the educated person is a habitual offender and he is being repeatedly doing it with so many people, Your Lordships. Prima facie, the Supreme Court is of the view that the investigation conducted so far suggests that collection of money from the depositors were neither legally permissible nor such deposits invested in any meaningful business activity to generate high returns. This is the view of the Supreme Court, not my view. Now, Your Lordships, the para 65, which was referring to the judgment currency notes, the currency notes seized by the police may be released, not must be released, may be released to the person who, in the opinion of the court, is lawfully entitled to claim after preparing detailed Panchnama. This opinion of the court, Your Lordships, is to be deduced from the lower court order and from the charge sheet and from the Supreme Court's order. This opinion of the court, if the court is of the opinion that it has to be returned to him, then it has to be returned to him. But the judgment also says that it can be returned to the investor or the claimant. In case the court is confused, then it has to be kept in the locker, Your Lordships.
Yes.
So this opinion of the court has to be deduced, Your Lordships, obviously from the charge sheet. The charge sheet is saying that it is from the proceeds of the crime. Supreme Court order is saying that it is from the proceeds of the crime. Trial court is also saying that it is from the proceeds of the crime.
The trial court has not said.
Therefore, Your Lordship's opinion cannot be contrary to the charge sheet or the trial court opinion or to the Supreme Court. Please, I did not interview. Please wait.
Yes.
Para 65, Your Lordship, from his judgment. Please don't interfere. Para 65 is that the currency note seized by the police may be released, not must be released, to the person who, in the opinion of the court, is lawfully entitled to claim after preparing detailed Panchnama. Is he lawfully entitled, Your Lordships?
Huh? Okay. You filed written notes.
Order is, Your Lordships?
No, you filed written notes.
Yes.
Yes, filed written notes.
Yes, filed written notes.
Filed written notes. Yes.
Sir, can you keep it on a
Written
short
notes.
date slot?
The matter heard at length. The parties are directed to place the written note of submission along with the relied upon judgment. You please highlight the paragraphs. Highlight the paragraph.
We have filed the written notes on argument.
Yes. You highlight the paragraph and give it. Okay. Mr. Naik will do it. Yes.
Next date, Your Lordships, is on.
I'll just see and give it. Yes. Huh?
It's a short date.
Yes.
So after 20th any date, maybe.
I'll just come in.
2021 vide order dated 27/2022 by this Honorable Court, my lord. And NBW issued on 18/4/2024.
Okay, 500. Yes.
27.
Properly note.
Lord,
Properly note karo.
petitioner was granted bail by.
Yes, yes.
Unless the petitioner was granted bail by wide 10028 of 21, wide order dated 27/22, and the NBW was issued on 18/9/24.
Okay. 500. Yes.
5 cases. 26, 27, 28.
20?
28 also same.
Same party?
Yes, my lord.
Same date.
Yes, my lord.
So another 31.
Different cases are registered on the same PS, my lord.
Bail granted on the same day.
Not on the same day.
Let us consider 28. Come to 28. Yes, 28. You tell me. Go one by one.
My lord, NBW was issued on 18/4/2024, my lord. And the bail was granted on 27/2022, my lord.
Yes. 500. Yes.
59.
My lord, NBW was issued on 17/8/2024, was on bail since 17/11/2018.
18. Okay. Okay. 500.
30.
Belgium warrant issued on 18/12/24. And 3 petitioners, my lord, they were released on 3 different dates.
Dates, give dates.
Yes.
19
One.
December 2009.
18/12/19. Yes,
One.
released on bail on 19. Thereafter, my lord, 22/1/20. Petitioner number 2.
2. Yes.
And
3.
3 is, that is, my lord, 28/5/20.
Got it?
20.
20. You got it?
Page 20.
500 each. Yes.
31.
Lordship, releasing bail 10029/21, Lordship. And that of enrolled is 16/4/2024, Lordship.
No, 500.
16/4/24.
Yes.
32.
32, Lordship. Date of order 3/5/24, Lordship. And 3/5/24, Lordship.
Okay.
And bail, Lordship. 4/10/21.
4/10/21. Okay. 500 each. Yes.
33.
NBW issue on 26/9/24. The date of judgment, petitioner could not appear. It's a Jagwan special.
When the date such on bail on bail when the judgment was to be pronounced in ICG case number 8 of 2019, the petitioner remained absent, and so NBW was issued. Yes.
Please.
Okay. That could be those sort of 47.
34.
Similar Belgium matter, enroll was issued on 23/2/2024, running page 11, annexure 1, lordship.
Yes.
Bail, my lord, by the London trial court and different dates, my lord. It's number 1/7/10/2011.
Give in writing. 1, 2, 3. Have you written anywhere?
No, that is not what I have. Later on, I have.
Write down and give. Write down. 500 each.
Obliged.
500 each. Okay. Write down. Write down the item number also. Yes. There are seven. You just write down. Yes.
35.
NBW was issued on dated 8/5/2024 and
8/5?
8/5/2024.
Yes.
And present petitioner was released on bail 5/6/2023.
5/6.
2023.
23.
23.
Why are you not speaking very clearly? Are you scared of the code or what? Tell clearly. Yes. 500.
36.
Based on my lord, warrant was issued on 2/12/2019, my lord. Bail on my lord 30/4/2014.
Okay. 1,000. Yes.
37.
Earlier offense 498/302. Earlier approach for
Case diary is not doing it.
Huh?
Case diary is not.
Case diary. Call for case.
My lord, I pray small thing.
Yes.
Material witness already examined. Father, mother, and brother of the deceased. Let's see, I pray CDS sorted.
No, short date will be given. This is the bail matter short date. Don't worry.
Cause of death is
And
strangulation.
get the, if you have that deposition mark.
Already supply, already.
Okay.
Already.
Just check it out.
Cause of death is strangulation. My lord.
Strangulation.
Other-
Now, what
other-
the witnesses have said.
Witness
other-
have,
other-
my lord. Witness nothing, my lord.
Any-
There is no
any-
evidence.
Any evidence has come?
Direct, there is no direct evidence. But 106 is attracted, my lord, because he is the husband. Cause of death is strangulation to the wife. Both were residing together.
My lord, PW 8, 9, 10.
Custody since?
Custody my lord of 13/8/2024. Sorry, 18/8.
Or third they are Kabishi. And what is the stage now?
Just my lord, already trial going on.
Going on, but how many witnesses are there? How many?
10 witnesses examined. Out
10?
Out of 26 witnesses. Material witnesses are examined.
They have supported the prosecution?
No.
Yes, just check it up.
My lord.
Okay. What do we for here? If not, they have not supported, then at least he is entitled to pay. Yes. Yes, next. 38.
Conduct, my lord. 38.
Yes. 38, yes, sir. You are there, 38?
38, my lord, 1095.
Permitted to
be given after examination of the
Withdraw.
after examination of the informant and renew my prayer.
Lord Counsel seeks to withdraw the present petition to renew his bail plea after the examination of the complainant.
Liberty may be given.
Material witnesses. Dismissal is withdrawn with liberty as read. Yes, sir.
39.
On behalf of Advocate S.K. Paddy, my lord, requesting for 1 week's time.
Adjournment on request of the petitioner. Adjourn. Adjourn you court to court. Prayer report. Yes.
40.
May I please, your lordship? My lords, petitioner is in custody since 1912-2024, 23, my lords.
1912.
1912.
23.
23, my lords.
Yes.
And your lordship, charge sheet submitted 376 2N 323 328 384.
Yes.
506 IPC, my lords.
Yes.
Earlier application was disposed of. I have annexed that order, my lords. Annex are 4, my lords.
4 annex. Yes.
And your lordship, after going through all the materials, my lords, paragraph 6 is important, 6, 7, and 8 important, my lords.
But what have I said?
My lords.
Examination of victim.
Yes, my lords.
Let us see victim statement.
Victim statement, your lordship, I am just reiterating those observations, my lords.
I read it now.
My lords.
Let us come to the victim.
There is the variance of statement of the.
I am not inclined to grant bail that time.
Yes.
Because victim statement has not yet recorded.
Yes, my
And the
lords.
material witness.
And my
Let us see the victim now.
Yes, my submission before lordship was that the victim at different stages has given different version of the incident. One in the affair, one before the medical officer while going for a medical examination, and one before the 164 statement. Different variants.
And now before court, let us.
Before court, my lords.
What does he say?
That is annexure 3, my lords.
Page 17 of the.
Page 17 onwards, my lords. Here also there is a lot of variance.
Yes, go on. Which part?
My lords, may I invite my lords' attention? Page 19, paragraph 5. That's page 19, paragraph 5. So it is in the form of negative assertion. It is not a fact, and the whole paragraph continues. It is not a fact that I have stated before the police that my father was assisting the RI in his official work, like mutation, etc., and that he was not having adequate knowledge in operating computer for doing the above official work. He was taking the help of the accused, who is having knowledge in computer, and that in the year 2019, my father was unable to attend the office of the RI due to his kidney problem, and that my father was doing the work while staying in the home, and that accused came to my house in assisting my father, and that in that prospect, I came to know the accused, and that in that course, accused became intimated with me and promising to marry me, forced me to keep physical relationship with him, and that in one hotel at Nilgiri, accused intoxicated the food and taking the same,
I became unconscious, during which accused had sexual intercourse with me and had taken obscene photographs of that process, and that subsequently accused compelled me to keep physical relationship with him, to which
He's already there in the custody for about 1.5 years.
My lord.
1.5 years. It's all right. Yes. 41, huh? Yes.
My lord, offense under section 20B2C and 29 of NDPS Act.
Yes.
And allegation is that the present petitioner was carrying 21 kg 450 gram of ganja in a motorcycle, and they were kept those ganja in one Mamta guest house and in a room number 102. And in this case, your lordship has granted bail application to one of the co-accused person, that is annexed.
Suman Mukherjee.
Yes, my lord. Suman Mukherjee.
Sumana Mukherjee.
Yes, my lord.
21 kg.
My lord.
Custody since?
Custody since, my lord.
Here, my lord, gone.
Huh?
Arms has been seized from the police.
Arms Act 25, 27. Arms Act, yes. Custody?
Custody, my lord. Custody since. Custody since, my lord.
What are you searching? You don't know custody or file? Regular bail.
Custody since 12/4/2024.
12?
12/4/2024.
24.
Yes, my lord.
Okay. And antecedent?
Antecedent, one antecedent, but of not similar nature.
Antecedents are there?
One antecedent of not similar nature, my lord.
File affidavit. Counsel for the petitioner submit that the co-accused in the present case has already been granted bail by this court by order dated 25/9.
Any criminal
24, and the recovery in the present case is
21.450 grams.
21.450 grams, and he's already in the custody since 12/4/2024. Already filed an affidavit detailing the antecedents. Yes. Okay. On the request, adjourn. Yes. One. Yes.
May I please?
Yes.
Petitioner is a lady behind bar since 12 February 2024, my lords. Initially a case under section 307, subsequently converted to
302.
Case diary. I have supplied deposition copies, my lords. None of them have supported.
Yes. Case diary. Okay.
Yes.
May I please?
Yes, sir.
My lord, the alleged offense under section 364, 302, 201, 120B, 212 and 25A.
Yes, I have an appear my on behalf of the informant. My power is not to let my lord respond.
Yes.
My lord, the petitioner is in custody since 10/10/2023.
10/10/23.
My lord.
Okay. Yes.
Allegation is that while the deceased was returning from the court, from the way the accused persons kidnapped him and committed murder of the deceased.
Yes.
This is the allegation, my lord. My lord, four witnesses, those who have named, some have named, and some have the role. What is the role played by the present petitioner?
They have been examined.
No, they have not. My lord, I want to the important eyewitness, that is Satya Patra, basing on which your lordship has granted one of the co-accused for on bail.
Yes.
May I place the statement of the Satya Patra?
Where is his statement? He is not placed on record. Where is that?
My lord, my friend, the state council.
Satya Patra.
Satya Patra has specifically implicated this.
Yes.
Three eyewitnesses.
Tell me names.
My lord.
You repeat after three examination of this. Repeat.
Shubham Shambhu Kuntia.
Shambhu
Kuntia. Bhagavan Parida and Satyapatra.
Bhagavan Parida.
Aye.
Bhagavan Parida
and Satyapatra.
Satyapatra.
The 3 are relevant.
Let the three.
Shubham Kuntia, my lord.
Let the three witnesses be examined.
My lord, one, my lord. Shubham Kuntia has not uttered the name of the present petitioner.
Yes, yes.
No, my lord. Has not uttered even his name. He is the friend of the deceased. On a WhatsApp call.
Read Shubham. Read Shubham.
He has not even uttered.
Yes. Has he said anything about Litu Naik?
My lord.
Yes.
One name Shubham.
Shubham, Bhagwan and Satya.
Vikram Parida, Lipu Nag. Present petitioner
Litu, not Lipu.
Litu.
Then my lord. No.
I am Litu, not Lipu.
Lipu is also an accused.
Yes, Lipu one of the accused. I am Litu.
Litu. Okay.
Shubham Kuntia doesn't utter my name.
Yes. What about Bhagwan?
Litu.
Then my lord, I have to examine it again.
You examine it.
My lord.
Who all are the eyewitness? Tell me.
My lord, Satyapatra.
These 3, my lord.
Mr.
These
Mahapatra.
3 are eyewitness.
Mr. Mahapatra enters appearance for the informant and seeks time to file the Wakalapnama. Release the matter. Yes. Litu and Lipu, there are 2 accused. Huh?
My lord.
You just see, concentrate on Litu.
I am with the impression Lipu.
Okay. Concentrate on Litu. Huh? Yes.
My lord.
Litu also been named by Satyapatra.
Satyapatra.
Also, Satyapatra is entered.
Then what about Shubham?
Shubham, my lord, Shubham is the person who was there at Surat. By way of a video.
You tell me how many witnesses?
Eyewitnesses
are Bhagavan and Satya.
Bhagavan, Satya, and Shubham also part eyewitness. Total not a total.
Let these 3 be examined. Then you.
One thing I pray, my lord, my friend, verify.
Okay. It's all. Okay.
In the meantime, 8 witnesses examined. In the meantime,
whether these witnesses are examined.
No, my lord.
Therefore, the ideal thing would be let them be examined. I'll ask the trial court to examine within 3 months and thereafter renew the bail.
But to my instruction, the Satyapatra was came to give his evidence, but fled away from the court.
Despite the fact that you are in the jail, you could influence.
No, my lord. That is not the fact.
He's so scared of you.
No, my lord.
The occurrence was also that one person had been to court.
Fairly, I am submitting.
With his way, he was kidnapped and murdered.
No, my lord.
Murdered?
No, on that day.
Dipu is the deceased. He had been to the court.
No, my lord. Kindly peruse the rejection order, my lord. Kindly peruse the rejection order.
It's all right.
The court has stated that.
Then let these 3 witnesses be examined. Let us. Right now. The petitioner is in custody. Petitioner.
Shubham को खाली place करते हैं.
Allegation shown. He is in custody since 10/10/2023. Out of total witness?
Confused you.
Total witness?
No.
Total witness.
Out of 9. How many witnesses have examined?
Now, 8 witnesses examined.
Charge sheet witness. Out of total charge sheet witness.
My lord.
Don't show 8 witnesses have already been examined. Mr. Pandal and the Council for the State submits that 3 vital witnesses, Shubham Naik, Bhagavan Parida.
28, my lord.
28, Bhagavan Parida and Satyapatra are the eyewitnesses to the occurrence.
Kindly your lordship, sir.
Eyewitnesses to the occurrence. They have not yet been examined by the prosecution. Hence, he submits that the bail application may not be considered at this stage. Regarding head to the aforementioned, the bail application at this stage is rejected. However, liberty is granted to the petitioner to renew the bail plea after the examination of the aforementioned 3 witnesses. If the trial court is directed to give preference, examine these 3 witnesses, giving preference over all other witnesses. It is expected that the same shall be done within a period of 3 months hence. And 3 months hence.
My lord, this order has already been passed by your lordships. Still then, after expiry of 6 months, the trial court has not initiated.
Where have I passed this order?
My lord, in my lord, Sanjay 1064/24.
Then more of you have not.
I am not the petitioner in that case. Your lordships.
No, but he is one of the accused. in this case.
My lord.
So then I can't supersede. Let me.
My lord, in that order, my lord, that you have your lordship has passed. They are Rudra Patra and Satya Patra. Categorically, your lordship said that these two eyewitnesses. This Khuntia is not eyewitness. So, my lord, these two, Rudra Patra and my lord,
Bhagavan and Satya.
Satya and Rudra, your lordship clarified that.
But you said Satya and Bhagavan, na?
My lord.
Satya and Bhagavan.
My lord. Bhagavan Parida.
Who is Rudra then?
Rudra is the brother of the deceased. Bhagavan, my lord.
Bhagavan Parida. May I read, my lord? No, you need not read. I want to know who are they. Where is Rudra? Rudra name is not here. Why are you showing this?
Rudra Prasad Patra.
Next.
My lord, within 3 months.
Yes, next.
May I plead your lordship? My lord, kindly list the matter after 1 week, your lordship.
Okay, on request, adjourn. Yes.
46. Obliged.
Can I take another 1 week after?
On request, adjourn. Yes. Learn counsel for on request, learn counsel for the petitioner. Requested for the on his request, matter is so you and put it in March end.
47, your lordship, may kindly see flag B, the earlier order. Your lordship, flag B, order dated 18/12/2024.
Yes.
At para 4 and 5. This is the order in the last bail application. During the investigation,
injured.
The statement of
Yes, Kundeswar Maji.
Kundeswar Maji. My lord, in the meantime, 7 witnesses were examined.
What about Kundeswar?
Kundeswar is PW3. I have annexed at page.
Yes, let us see Kundeswar.
Page 16.
Yes.
Page
Come to
16.
Kundeswar.
Yes, not supported, my lord.
Yes, Kundeswar. Let us see.
Page
Kundeswar.
16.
Kundeswar. Yes. What does he say? Kundeswar. Yes.
I know nothing about the incident. Yes, my lord, petitioners are ladies.
Husband of the deceased.
But 302 is there and the CD is not with me, my lordship.
नहीं see that सब देखी थी ले आपको.
But no, nahi mo pakre kichi to mo pakre kali what petition task.
Deposition copy सब देख.
The deposition को पूछा होता है किसी नहीं किसी नहीं.
What
Your lordship on the
injured witness not supported you.
Not
Yes.
one eyewitness. He is not
My
supported.
lordship CD is not there and only deposition copy and FIR is there. in
On
my
the
case.
earlier
See the deposition. Last time I rejected.
Yes.
Because the story is this witness, Kundeswar, says that I was sleeping with the deceased
Yes.
and these accused persons came beaten,
Yes.
black and blue. Okay, I was also injured and the deceased died. And she is an injured witness,
Yes.
very important witness. And she says that I don't know anything now.
Yes.
And what will you do?
And these petitioners are ladies, my lord, and one only
What
four
will you do,
petitioners.
madam? Injured witness is not supported, then what to do?
Right. Only eyewitness.
Chaudhali Maji,
Yes.
Dada Kali Maji, and Padmini Maji.
And Mittu Maji. Mittu, and petitioner 1 to 3 are ladies, my lord. They are in.
Would you like to say anything?
No, my lord, so I don't have anything in case.
Right,
There is
deposition
nothing.
page.
Only deposition.
Can you read the deposition and
Yes,
shall I put it
Yes, sir.
next week?
Yes, my
Next
lordship.
week, okay. Next week. It's a murder case, let us
Yes, my
let
lordship.
read.
302 is there.
And
Just
they-
see the if you think that any other witness is yet to be
Yes.
examined,
Yes, my
which
lord.
is very vital to the prosecution, you just examine that.
Yes,
Your
my
But the injured witness is not supported, then he is entitled to bail.
Yes, my lordship.
On the last
Because
occasion,
injured witness was he said that he was with the deceased.
Yes, my lord.
Both of them were beaten up,
Yes, my lord.
and this is he died and he survived. Such a vital witness not supporting you. Just check it up next week. Huh?
on the
Next
last
week,
occasion, lordship broadly decided. Hello, got a date, go die for them next week.
Next week we'll give a date. It's a bail will be. I'm just scrutinizing all the matter today. Wherever there is a chance of getting bail, I'll reach it next week.
Right.
Where there is no chance of getting bail, I'll adjourn it for a longer time.
And because my lord, these petitioners.
I'm just scrutinizing the in one.
Lady good as
So wherever there is a chance of getting bail, I'll put it next week.
Yes.
Next week is proper.
my lord.
And where there is no chance of bail, I'll adjourn it for a longer time. Okay? Yes.
48.
No.
Yes, 48. On a period, yeah. Okay.
49.
Yes. Yes.
Lords, the prosecution cases, my client's name is Tarun. my lords. Prosecution cases that, my lords, one Akash Patnaik, who is the pai, who is the husband of Neta Naik, he suspected that one Suraj, the deceased, had an affair with his wife. So there was a quarrel amongst them on the 13th, 14th.
Suraj and informant.
Suraj and the informant. Suraj and my lords Akash, they also had a fight on the 13th.
Suraj deceased.
Suraj is the deceased. No, 14th, he takes Suraj and goes away with two other persons. Now, my lords, insofar as this present petitioner is concerned, Tarun, he had come to their house on 13th and gone away. That is the statement of the wife.
Wife of the.
Now, my lords, nothing, because this is a last seen theory. Last seen theory also, it doesn't, my lords, is not attracted in the case of Tarun, because the day before he had come to the house and just gone away. And Akash Paik is the main, Akash Naik is the main accused.
Leading to discovery, so that was.
And leading to discovery, everything has been seized from him. Akash. And he has gone with two persons. And Tarun, my lords, he comes the day before and goes away. He has also been roped into this case.
And what else against Tarun? Any recovery, anything?
Anything else? No recovery, no.
Yes, madam.
My lordship, 161 statement of the informant, my lordship. May I read your lordship? ମୋର ନା ଶଙ୍କର ଦାସ ବୟସ 32 ସୋ ମୋର ଭାଇ ସୁରଜ ଦାସର ମର୍ଡର କେସ୍ ଟାଉନ ଥାନାରେ ଦେଇଥିଲି ଏସବୁ ଖବର ପାଇକରି ଆମେ ବହୁତ ହେଲେ ଯେତେବେଳେ ଆକାଶ ପାଇକ ବଣ୍ଟି ପାଇକ କାଜୁ ଭାଇ ଅରୁ ତରୁଣ ବାରିକ ଏକା ସାଥୀ ଧରା ପଡି ସବୁ ମାରିଥିବାର କଥା ସ୍ୱୀକାର କଲେ ଅରୁ କେନ୍ତା ମୋର ଭାଇ ସୁରଜ ମର୍ଡର କଲେ ତାହା ଦେଖିଲେ ସେତେବେଳେ ମୋର ମନେ ପଡିଲା ଯେ ଗଲା 13/7/23 ତାରିଖ ଦିନ ଆକାଶ ଅରୁ ତରୁଣ ଗୁଟେ FZ ମୋଟରସାଇକେଲ ରେ ଆମର ଘରକେ ଉପର ବେଲା ଆସିଥିଲେ ପ୍ରାୟ 2:30 ରୁ 3ଟା ଭିତରେ ଅରୁ ସେମାନେ ମତେ ମୋର କନ୍ୟା ଅରୁ ମୋର ଆଈ ସମକୁ କହିଲେ ଯେ ସୁରଜ ଦାସ କେନେ କରି ଯାଉଛି ଆକାଶ ଘରେ ରହିକରି କାମ କରମୁ ବୋଇଲେ ଅରୁ ସାଙ୍ଗେ ନେଇକରି ଗଲେ on 14/7/2023.
When the dead body record?
And I also said that.
When dead body record?
Yes.
14th is recovery of the body, and 14th the murder takes place.
9th these people were.
Yes, and your lordships may see the statement of the wife. She says, my friend will be placing it, my lords.
Yes, sir.
You are in custody since?
Custody
16/7/2023.
16/7/23.
Yes.
16/7/2023.
23. Yes.
The wife said, just he place it, my lord. That
what is the stage of the trial?
That has not been.
Stage of the trial.
Because out of 25 witnesses.
I'm calling for a report.
Yes, my lord.
Call for the report from the trial court regarding the status of the trial. Let us see if the trial takes a lot of time, then because except the confessional statement, he says that the complainant also says that they have confessed.
No, my lordship. One thing is that the mother also said that that Tarun and that other person
they came.
Yes, and took her son with a bike.
What is the motive? They might have taken. What is the motive?
The
motive is also very
because of they are saying that the deceased wife has a relationship with that.
The wife
has a relationship with the deceased.
Gives the same statement. Rather, she says Tarun had come and gone away.
Tarun has nothing to do with that wife.
Nothing. He is not in love.
Tarun's friend Akash is there really.
Akash Padeji. And the wife herself says, she is the best person to say. They are living in one house. Tarun asi chali gala.
The wife has a relationship that's why
Let us see the trial state. Yes. If witnesses have been examined, we'll see. Yes. Please. Yes, short detail. ଗୋଟେ week ପରେ ଦବ next to ଛାଡିକି ତାର next week ଦବ report ଆସିବ ନା yes yes 50 on the request of the counsel for the petitioner release the matter also here
yes sir the petition in custody since 18/7/2023 my lord 18/7/2023
20 okay
come to page
20
23 my lord 18/7/2023 come to page 10
CD is not there, my lord, sir. 302 is there. CD is not there.
FAR chart sheet postmortem they have given the entire
Status of the trial.
Call for CD call
yes. Chart sheet postmortem report co-accused valor sabu dekh sakhe
she is not prepared obviously yes
yeah
51 time
proceed
and wherever the bail matters are adjourned, you prepare and come so that we will dispose it up.
Go to stand on similar period already granted bail by lordship.
We'll see. Next check.
As yours.
Next. Yes. Yes. Yes, sir.
My lord, the petition is the second round litigation before lordship. Petition is custody from the 7th April 24. On 7th April 24.
Yes.
In order dated 29 September, lordship direct to renew his prayer before the submission of the charge sheet. Already in this case, charge sheet is submitted. Thereafter, the petition is before your lordship. The FIR was registered under section 363 and the charge sheet is submitted 363, 366, 376 2 and 376 3.
376 3.
Yes, my lord.
Yes. And read with 6 of
Notice.
POCSO Act.
Section 6 of POCSO Act.
Notice. Notice was issued. 376 3 is there. Notice has to go. Notice to informant and victim. Okay. Yes.
My lord, date, ma'am.
After 3 weeks. Yes.
53, I am in BC, my lord.
Yes, sir.
Here, my lord, the alleged optional section 420 along with other offences, charge sheet has been filed. The quantum involved in this case is that 7,90,000, my lord.
Custody since?
Custody since, my lord, 20/12/2023.
Sorry?
20th December 23, my lord.
20/12/23.
Yes.
Yes, my lord. Allegation is that, my lord, the informant wanted to purchase a vehicle, my lord. One Chinmay Ranjan Sahu has introduced himself to sell the vehicle, and the purchase the vehicle for the amount 14 lakhs. One Chinmay Ranjan Sahu, he has demanded an advance of rupees 8 lakhs, and also said that the amount may be deposited in the name of the present petitioner. Accordingly, the purchaser has deposited an amount of 7,90,000 in the account of the present petitioner. The person who has shown that Chinmay Ranjan Sahu, my lord, he has already been granted bail. And so far as the present petitioner's allegation that, my lord, Chinmay Ranjan Sahu has requested the purchaser to deposit.
Where is Chinmay's Sahu's bail order?
Is that before the learned trial court, my lord, he has been granted bail. That has been reflected in the rejection order, my lord, para 2. On bail by this.
You are the friend of Chinmay. Yes, madam.
My lordship, I'm reading the operative part of the charge sheet. During course of the investigation, basing upon the statement of the complainant, each witness number of four-wheeler vehicles has been seized from the different purchaser, which are sold by the accused person Chinmay Sahu, Gopal Prasad, Jay Prakash Naik, and Jiban Mondal. The accused person assured the purchaser that 3 vehicles are brought from the Calcutta, which are repossessed by the financer with up-to-date documents. On verification, it is ascertained that the number of the engine and chassis of the vehicle are tampered and engraved by the accused persons, which are clarified by the experts of the state.
Chinmay has already been granted bail. You are appearing for?
For the informant.
Yes. 7,50,000 rupees on the promise by Chinmay. You have
Yes.
transferred it to this account of the petitioner. Account of the petitioner. Chinmay has
Yes.
already been granted bail.
Yes.
And he is already in custody since December 23.
Yes. Case of rackets, 8 knockers of 4-wheelers, 110 Australia top with it. So to run and became good. But a racket went that far, but the petitioner.
They used to do all those things.
Most went. So Lordship, please let them direct to deposit the amount in the court below, man. I'm not taking that.
No. What is the how many vehicles are recovered from him?
88 vehicles.
From this petition?
Yes, my lord. They are working together, my lord. So this 4 person and 8 vehicles has been recovered. And where the chassis number is different. And
What is the stage of the trial?
that, my lord, so I have to take the instruction.
Get the information. Huh?
Yes, my lord.
Charge has been framed below, no, trial has not yet been commenced.
Not yet commenced.
No.
And this may be called for Melo.
I'll call for a report from the EFC court, court below regarding the status of the after 2 weeks. Yes.
55.
Yes.
I prefer my time, Melo. Pray for time, Melo.
Okay. On the request of the Learned Counsel petitioner, yes.
56.
Recollect that matter. Likely to commit.
Yes. What to do?
My submission before your lordship is that, my lord, likely is a word. It is not right now, so far as I am concerned, likely that somebody else will also named me. Because on the basis of the co-accused statement, I have been arrested.
You have been granted bail, but
yes,
because of the condition, you are not able to come out.
Yes.
No.
You have not been granted.
No. My lord, I have not antecedent. Because of the antecedent, your lordship may kindly see your lordship's order dated 8/1.
8/1, huh?
Yes. And I have also filed the written note as has been directed by your lordship.
Yes.
Paragraph 5, your lordship may.
Yes.
Para 5 and para 8.
Okay, bail was about to be granted because of the. Okay.
Only
There is on merit you are entitled for bail.
Yes, on
But the only
merit,
problem is the 2 cases.
likely to.
And my lord, it's in one judgment, I also.
My lord, that judgment is not applicable. Once your lordship is satisfied that I have no connection except the co-accused statement. That judgment relating to that only. So far as likely to commit, that is the issue before your lordship. And I have also filed the one judgment. There is a possibility. Likely to means that.
That's right. But the judgments are, none of the judgment have dealt with that point.
No.
That's the difficulty.
And apart from it, my lord, I have also, there is another judgment, 2004 Supreme Court, I have not brought that, 1517. In that case, sentence under the IPC was considered. So somebody has been injured and there is a likelihood that he may die. But that is not applicable to this case. Because in both the antecedent, I have been granted bail. Because I have been entangled on the basis of the co-accused statement. Right now also in this case, I have been entangled on the basis of the co-accused statement. Nothing has been recovered.
No, that is on merit you case.
Yes, I am
Only
having.
thing is antecedent how to get
Then
over
it
it.
is up to your lordship's discretion, and he is a local man.
What is the recovery? How much is it?
420,
No
nothing from
recovery.
me. Nothing from me, 420 kg. Your lordship has also କି ଜବରଦସ୍ତ କଥା କହୁଛି କହିଲେ ଗୋଟେ ଦିଟା ସାକ୍ଷୀ ଯାଆନ୍ତି ଅଜବ କଥା.
He's finding out the practical solution.
My lord, ultimately I will be at
Custody since
my lord custody.
They have written.
2024.
Huh? 13/8/24.
Yes, 9/7 occurrence. I was arrested on the basis of no. Abscond, my lord. I have been entirely on the basis of the.
No, in fact, on that day,
Yes.
8/1/2025, I have already written everything.
Everything your lordship.
Only because of
Jotted down. Yes, jotted down everything.
antecedents have.
How to get rid of this?
My lord, that judgment is.
I will see what I'll do is I will ask for the what you call status of the trial and reproduce all this thing. Invoke Ravi Prakash and grant it to me. That's the best way of doing it.
Yes, yes.
In this, but we can't get out of that.
Yes, ma'am.
It's better. Call for a report from Sessions Court and status of the trial. I'll invoke Ravi Prakash and
Your lordship.
because I have already I have given this thing only on the basis of co-accused statement. And see, I have written it. I have written it that the State Council says that there is nothing except co-accused statement.
Yes, the lordship keeping
So
it.
this is a case where Ravi Prakash can be penalized.
The lordship keeping it to my lord.
Good week for it. You will take charge next week. Report assured.
Yes.
Your Lordship, 57, I'm praying for a Passover.
Passover? Passover, please.
Lordship was pleased to direct for obtain instead status report was called for, my lord, right? Order dated 4/12/2024, and it has already been received. That and as per my instruction also, my lord, that one witnesses has already been examined, my lord, since long.
One witness has already been.
Aye. And till date, my lord, no progress in the trial. And in this present petitioner filed bail application before this honorable court, my lord, earlier. And your lordship had order dated 5/8/2024 was pleased to direct the present petitioner to renew his prayer before the Lawrence trial court. And this present petitioner is in custody since 19/6/2023. And 19/6/2023.
Yes.
And my lord, he has no criminal antecedent. And my lord, that
recovery is 417.
I was driving the vehicle Bolero. I was driving the vehicle, my lord. That is the Bolero.
What is the status of the trial?
Status, my lord, it is actually.
No, that status report was obtained in the December 2024.
Yeah, and it has already been come.
Test status.
Test status report.
ଆସିଛି ରିପୋର୍ଟ ଅଛି ଆଭେଲେବଲ ଅଛି
ନାଇଁ ଆଉ ଆସିନି
ନାଇଁ ଆସିଛି ନା ଡିସେମ୍ବରରେ ମଗା ହେଇଥିଲା ସେ ରିପୋର୍ଟ ଆସିଛି
December
ଲେଖା ହେଇଛି
11th December 2024 the report has come.
ଆଜ୍ଞା
There is only one witness.
ଆଜ୍ଞା ଏଇ ତ ଜାନୁଆରୀ ମାସ ଗୋଟେ ହେଇଛି ତାପରେ ଆଜ୍ଞା ଆଉ କିଛି ହେଇନି ସେଇ ରିପୋର୍ଟ ଏବେ ଆସିଛି
Posted to 16
ଦେଇଛି
16 ଏକର ଥିଲା
ଆଜ୍ଞା
just adjourn it for 2 weeks. Let us see. You, Mr. Jana, see the last last report is one witness examined, matter is posted to 16/1/2025. And for the evidence of rest of the witness. Let us see what are the get it. State Council to obtain instruction regarding the status of the trial is the matter. Yes. Next.
59. My lord, fix up a date, my lord.
Date will be fixed, don't worry about it.
Next week, my lord.
Yes, date will be fixed one.
Next week, my lord. I pray for.
You will give. Good week, Chadi.
Yes. May I please? And it's the second application of the present petitioner after examination of the victim, my lord. And the petitioner is in custody since 9/11/2023, my lord. Age of the victim is 27.
9/11/23.
27, my lord. And the present petitioner is the cousin of the victim, my lord.
Yes.
I have annexed.
164. Read 164.
My lord, 164 is that page 36, my lord. Examine, my lord.
Examine.
Yes, my lord.
Show me.
Kindly have a glance to running page 41.
41,
my lord. The relevant
copy of deposition. Yes.
Yes, my lord. The cross examination,
41.
my lord.
PW1.
Yes, my lord. The victim.
Yes.
Victim has examined at PW1. Aged about 35 years. My lord.
Last year in the month of Dasara.
Cross examination is right on, my lord. They have relationship last 20 years and the affair was lost after 9 months of the occurrence.
So they came to a house at that time I was alone. He told me that
Known to each other since last 20 years.
yeah, I love you. Describe your name. Yes. Yes.
My lord, affair lost after 8 months of the occurrence. 8 months after the affair was lost, my lord. Victim is major, my lord, and the petitioner is his relation, my lord. And my lord,
Show me medical. Show me medical evidence.
Medical evidence is completely silent.
Do you have medical?
No.
Yes, so.
And that in cross examination, she has stated that they have they're known to each other since last 20 years. They're known to each other since last.
Oh, cousin brother, not do, obviously. It looks like one-sided love. She is a married woman. You went to her house, showing Bujali you raped her. That's the allegation.
I'm kindly have come to the cross.
Medical evidence.
Not there. Any bodily injuries?
No medical evidence.
Yes. No sign and symptom of recent sexual. After incident, when the incident?
Incident, my lord.
Incident taken place on?
No, 11/2/2023.
11/2/2023.
FIR was lost on
FIR?
8/11/2023. After 9 months.
23.
Yes, ma'am.
Yes, this is a good point for 3 days. No sign and symptom of so. This was done on 9/11/23. Okay, 8. Okay. Obviously, after 8 months, what will come?
Not found, my lord.
Yes. Cross examination, let us see.
My lord, cross examination.
Yes.
Running page 41, my lord.
30? 41, yes.
My lord, the paragraph, I'm placing the relevant paragraph.
Which paragraph?
My lord, paragraph 13, my lord.
13,
My son and daughter are studying the and rest of us doing cultivation. I have a bank account
2 years back.
2 years back, approximately 1 lakh was there in my passbook. Prior to the occurrence, I had paid 7,000. Then monetary dispute is there, my lord.
Not remember.
Then, my lord, the paragraphs 15. I had known the accused since last 20 years past. They are known to each other, my lord, and frequently coming to the accused.
And it's cousin brother.
Yes, my lord. I do not remember whether I have stated before the magistrate of Riyamar in 161 statement, 164 statement that the accused by threatening me in the name
The
of.
problem is you have also taken 70,000 rupees.
My lord, then my lord, kindly come. And then my lord, paragraph 20, my lord.
20, okay.
From the
date of the first occurrence.
Till 8 months of the continues to come to our house, my lord.
At that time
from the occurrence till 8 months, he has not given any affair or anything alleged against the present petitioner. And my lord, paragraph 22, my lord.
22, yes.
It is the fact that I used to talk with the accused and
The only point in your favor is FIR after
yes,
8 months.
But she has narrated. Why?
Except that there is nothing in your favor.
and it's a second successive
Huh?
application.
What is this, child?
And custody, my lord.
Because very specific statement. Not only the 376, but also you have taken 70,000 rupees and it is bank transfer. Bank transfer, you have taken photographs
No,
and
my
receipts.
lord, kindly have a glance to running page 36.
36.
The 164 statement.
Yes, 36. Yes.
164 statement.
Yes.
He has not narrated regarding 70,000 in the 164 statement. That
And
was
this, he has even in cross exam 1 minute. In the examination chief also he is not said anything. It is you who has kept on asking him.
my lord, she was developing by day by day, my lord.
Why have you asked this question? Why have you asked this question? If this is the kind of trial you conduct, what to do? He has not said anything in the examination chief. You should have bank account, how the money transfer, everything you have extracted in the cross examination. They see. They see. Was it necessary to ask this question? Huh?
But in the
FIR, but see the question in the examination chief, she doesn't whisper about the money transaction. And the cross examination, they started account number, AO, all these things.
Yes, fine.
This is, and if he will not be defended, he would have been acquitted.
Yes, ma'am.
The prosecutor is doing good job for you.
Yes.
And the defense counsel is creating problem. What to do? These questions are being asked like this. Let's see the questions.
Yes, ma'am.
I'm just wondering why these questions were put to you. Here.
clear type of
Everything is extracted in the cross examination. Yes.
And man, paragraph 9.
Let us see the trial justice call for a report for that. The only point is the FIR is registered after 8 months.
Yes, ma'am.
That may be a reason for grant for bail.
And both are major and they're in relationship.
But allegations are serious. Yes.
60.
Man, next week one.
Good week chhadi.
My last occasion, my lord has asked for the status report. Status already come.
Sir?
My lord has asked for status report. That is a flag 8 flag DL. And the petition is custody since 18/3.
18/3?
2024, my lord.
24, huh?
Yeah. And out of 45 witnesses, 4 witnesses are examined by the prosecution. I have filed the deposition of the witnesses. Nobody is supported. Angada Kahar is the informant. Page 91 again, litigation order.
4 witnesses have been examined.
Yeah.
Out of 38 witnesses.
45.
38.
Charge sheet the 45 again.
38 is I report.
Yeah.
The status report which I have called for, that status report says out of 38 charge sheeted witness, 4 witnesses have been examined.
Charge sheet 45 again.
So then trial will take time. Let us come to the merits.
double murder case.
Double murder case,
the suspecting witchcraft.
All
Let it be double murder. That's not the issue. Is any evidence is there or not?
No matter.
Bharat Digal and Reena Digal.
Page 91 देखो लगे registration order.
Yes, Bharat Digal, Reena Digal देखो. Evidence नहीं.
तार ना किसी ना allegation नहीं है.
Bharat Digal, your lordship may kindly see unless this petition has been examined by law. This is circumstantial evidence, no admits to the occurrence.
Yes.
And so they have disclosed that they have killed these 2 persons by giving money to one Sunil Digal. And then they have killed man.
One Nibak has paid the amount to the Sunil and this. Yeah. Deposition of the Kondanga Lekhaiji.
Statement for statements of Tupei Connor. घटना रीना दिगल पिता विजय देला आम घर आसी मो सासु शशुर बर्तमान केउटे अछंती बोली पता थिया मु तांको षडयंत्र विषय न जानि पारि
मोर शाशु को शशुर एवं काली बाहरी गेटारे अछंती कहबार से विषय जानी आम घर पलाई परवर्ती समय से षड्यंत्र कर मोर शाशु 85 कनर और शाशुर हीरा कनर को योजनाबद्ध भाव सुनील दिगल भरत दिगल रीना दिगल अजु कनर रिंग कनर उग्रेशन कनर वृषभ कनर हाथुड़ी पिटी पिटी हत्या कले
Actually, they conveyed a meeting and the informant is participated in the meeting also.
Let him come.
My turn.
Why are you overlapping?
दिगल एवं भरत दिगल प्रत्येक 10,000 लेखा आदाय कर सुनील दिगल को आने फुलवाणी गले रीना भरत अजु फुलवाणी को जाई सुनील को गत 7/3/2024 घर आनी योजनाबद्ध भाव में मोर शशुर हायर 85 करोड़ हत्या कले
Whose statement you are reading?
I am reading the statement of Kupoi Konhar.
Huh?
Kupoi Konhar.
To koi come. Yes.
And another matter,
Yes.
Nigraj Konhar also.
Angor Konhar.
He has stated so.
Lingaraj and
Okay.
Kukui.
My.
And who else?
He also my lord leading to.
You tell me who all are the vital witnesses. Next week. Land Council for the Mr. General and Council for the state to inform who all are the vital witnesses for the prosecution. Yes.
61 people dita 50
ଆପଣ ନା ଦିଅନ୍ତୁ କି
ମୁଁ ଦେଇ ଦଉଛି ଆଜ୍ଞା ସେଟା सोमवार ଗୋଟେ ଅନ୍ୟ କେସ୍
ଅଲଗା case ରେ ଅଛି।
ଯୋଉ କଫ୍ ସିରପ୍ କେସ୍
My lord has kept it to Monday. Similar case. So it come on Monday.
नहीं सिमिलर नहीं देला এটা तोल करना which draft वाला
61, 62 my lord. Next
61 62 okay okay Monday
next two item.
okay okay I thought which draft है कब सिर्फ 61 62 Monday हाँ yes
My lord, item 60 take a keep of again.
he will give next week देखिए गुटे week छाड़ी
My lordship, item 24, my lordship, it needs an amendment. I am filing a memo to withdraw the application with liberty to file a better application.
that's a better idea because you have not
Mentioned
20
will take time. 24 item.
24 Land Council for the petitioner seeks to withdraw the petition to file a fresh petition with all relevant particulars. You file a better one
Yes,
in
yes, yes.
ठीक है okay
Beg your pardon, your lordship. Item number 96. I am through VC lordship.
19
96.
yes what do you want
Lordship, praying for an adjournment.
96
On
years ago
behalf of senior Mr. B.K.
bill कितना रहेगा
node is there for the
Mm-hmm.
first hour node is there for that real lordship.
Yes. Now you tell me what are the materials?
498 of the office, sir.
498 days.
Mine.
Then I'll hear it later on. Non-APS or even in the second call in the interest of justice, April. Yes, yes. That is my point dismissing, yes.
May I please, Your Lordship?
Yes.
Item 5, my lord. Your Lordship, here come against a summoning order. Your Lordship, last occasion directed to file the charge sheet. I have filed the charge sheet that is on in the record along with an additional affidavit. In that charge sheet, I want to draw your Lord's attention that page 63 of the internal page 63, and I have marked it page 102 for continuation of this brief. Along with that additional affidavit.
102. It is not scanned. Do you have?
4179.
Have the extra copy? Not scanned. Not please.
This is the certified copy.
You have extra copy?
Yes, I have another
Yes.
copy.
What do you want to say? You have filed it, huh?
Yes, I have filed it. I have filed it.
Okay. It's not scanned anyway. What do you want to show?
My lord, here paragraph 18.9.
Abhay Kumar Sahu.
After the yes.
Rajesh Kumar Sahu. Yes.
Abhay Kumar Sahu, Rajesh Kumar Sahu, and connected application is Mohindra Behra. Another application is there. 3 applications in this present case. All 3 are connected because the allegation that by way of a forged transit pass, the coal was being transported. It was the allegation. The transit pass which was issued in the name of the transporter of the connected application Mohindra Behra, that was initially suspected to be forged one. That's why this case was registered. All the 5 transit passes were sent to the mining officer and expert regarding its genuine examination about the genuinity. And the mining officer has reported that 4 transit passes were forged. 1 is genuine. That 1 genuine is of Hingula Transport, which is of Mohindra Behra. And the present petitioner of the 4179 are the owner and driver of the vehicle which was being transporting that vehicle with that transit pass. That is why I am showing to your lordship that the letter number they have quoted and that letter I have annexed. Your lordship, last person mark.
Sufficient evidence could
not be substantiated against other suspected accused persons. Similarly,
no evidence regarding the possession of
no evidence regarding possession or use of firearms, Article 25-27 of the Act could be substantiated. I have also requested the Deputy Director Mines Talcher by this office letter number 6013 dated 24/12/2021. This is available in Annex 3 of my application to certify the genuineness of the documents and to attend the query.
5 sets of transit pass.
5 sets of transit pass. Out of that, 4 destination pass were found to be forged. Now, your lordship may put me a question that if it is mentioned only 4 transit pass, how can I am connected with 51? That is for that purpose, I am taking your lordship to Annexure 3. 3.
Which is that the 5th one? How will you distinguish the 5th one?
That is why I am taking your lordship to Annexure 3. Yes. Page 35.
Yes. 35, yes.
Page 35 it starts from clause number 2, the one Roman 1 2 करके देइछन्ती. Page 36 रे clause Roman 5.
Yes.
Check get copy of destination copy of 1 transit pass yellow color in form such and such dated on such and such in favor of truck bearing registration number OD 35B 1594 by the Talcher Circle Department so and so alleged A8 and A19. It was sent for the examination. Now next is the report. Page 37. The MCL reported that kindly refer to letter number 22 on the refer subject. In this connection, this is to inform you that as per record of our web bridge, the e-transit pass number such and such dated 16/10 to 2019 issued against vehicle number OD 35B 1594 as asked for has been generated on the aforementioned date from the Bhubaneswari OCP Bhubaneswari area. Now the relevant is page 38.
38, huh?
Yes. Last clause 5. The destination and check gate copy exhibit A8 and A9, which I showed your lordship in answer 3, of the e-pass number such as relating to vehicle number OD 35PB 1594 has been generated from Bhubaneswar OCP of MCL, which has been reported by the project officer Bhubaneswar OCP seems to be genuine. Also, the same may be cross-examined with seal and signature of the Bhubaneswar NCP file letter.
Not to be genuine.
Yes. And now you're in the charge sheet also,
They say that this is the genuine one.
genuine one.
Yes.
Still then, why they have charge sheeted the present Mohindra Behera? Because of Mohindra Behera, all these petitioner of 4179 are there. They have stated, the IO has stated.
How can you dissociate yourself from the 4 transit paths, which is found to be false? How will you dissociate?
Only I am my regular transport. The other 4 transit paths were issued against other transporters, not against my regular transporters.
This is only, this is regarding Mahingula.
This is the only Mahingula transport or the only transit pass.
Show me the other transit passes. Yeah, it is there.
It is there.
Destination exhibit A2 relating to
Serial number 1.
Hingula. You are Hingula?
I am Hingula.
And Hingula OCP, MCL. Hingula OCP, MCL. See, the transit pass A2, A4, A6, and A1.
Yes.
These are four.
Yes.
Where from I'll get that it is A8 and 9 belongs to you. Where from I get it?
That vehicle number it is mentioned.
Only
Vehicle number.
Vehicle number. No, transit pass issued in whose favor? A8 and A9.
A1 price 38 euros.
No, A8 and A9.
8 and 9 is the genuine one. What is
Genuine one only, it was issued in whose favor?
Angola e-pass number and destination copy. Electron waiting note so is found to be false and fabricated one. The same has also been confirmed by so authority of Hingula OCP MCL White.
I am asking 8 and 9 issued in whose favor?
It is in favor of vehicle number it is mentioned.
Vehicle number,
Yes.
but it must be in the somebody's name.
Vehicle is in the name of Rajesh.
Where is that? How will I connect it?
That is the seizure list se man dekhe.
Then that is the issue. That is the issue is-
Seizure se man
and
dekhe.
then I have to conduct all inquiry and everything,
No.
and distinguish thing and pass a judgment. These things is not the job of the 482 court at this stage.
No, that
Then
is
you
correct.
have to
15 how I am connecting 1594 with
so
the-
everything has to be placed black and white and connect and see the link and everything will be done by the court below in the right stage. Not I in the 482 court I can't read every
No, I have from the very beginning also your lordships that question was there. My reply is here there are
you
numbers of-
appropriate application before trial court. I give you a direction that the trial court will deal with it.
that
Huh?
I have mentioned
20
I have
Paragraph 22.
of my petition. I have make an amendment to that effect.
Yes.
At this time of framing of the
What is that? Para
22.
22.
That it is most my place.
Yes.
That it is most relevant to submit here that admittedly the petitioner has the remedy to raise all the above points at the time of framing of charge. For in the present case, looking into the numbers of the accused persons involved in the case, more particularly the appearance stage has not been yet to be completed, is not sure. So he is also.
No, you have appeared, na?
Yes.
Then insofar as your case is concerned, it will be considered. I'll give a direction to the trial court. Forget about the other people whether they are appearing or not.
If your lordship give a direction to split up the case.
No, for application. I am not. Trial will be split up later on. At
But
the
the
stage
stage
of
of charge, framing of charge stage has not yet come because appearance is not completed.
appearance, let them appear or not, that's not an issue. Issue is
I am not
you
also-
move an application, your application will be considered because you are appearing. Charge will be framed after appearance. You move an application, separate application under 227.
227, I think that will not be taken into present consideration unless the appearance is completed. It is fixed for framing of charge.
You have already appeared.
Yes, yes.
So far you are concerned, you are.
Yes, yes.
See, in the, for the purpose of framing of charges,
Yes.
appearance of all the accused required.
Yes.
For the purpose of deciding your application, if you are appearing, it's all right, let it be decided, I'll give you direction.
That is
That I'll give you direction, right now. Petitioner is seeking passing of the entire FIR and entire charge sheet. My petitioner is accused in one of the accused in FIR number so. Allegation against the prisoner. After investigation, charge sheet has been filed in the present case on 5/1/2023. The Clearance Counsel, Mr. Mahapatra, Clearance Counsel for the petitioner submits that even if the allegation made in the charge sheet is taken to be true, or no case is made out against the petitioner because the transit pass issued in favor of the petitioners, in favor of the petitioner, found to be genuine as per the investigation by the police and investigation of the police. He has relied upon the part of relied upon the passage from the charge sheet to substantiate the case. Mr. Mahapatra submits that out of 5 transit passes, 4 transit passes found to be false, whereas 1 transit pass is found to be correct, which indeed has been issued in his favor. Therefore, the investigating officer has the investigating officer, despite recording the above passage, has filed charge sheet against him, which is not sustainable. It's not sustainable. At the same time, Mr. In the petition, the petitioner has averred as under para 22 of the petition. The apprehension of the petitioner is that since there are a number of accused persons implicated by the prosecution, and the matter is that the appearance is his application for discharge may not get audience before the appearance of all the accused persons. The apprehension of Mr. Mahapatra expressed in the aforementioned paragraph reproduced from the petition is unfounded because the petitioner has already appeared in the court. Therefore, if he moves an application for discharge, the same shall be heard independent of the fact that the other accused persons have not appeared. And with this liberty, the petition is disposed of. Yes. Move application. Yes, next.
11.
All both the 2 applications.
Both the applications.
And you will also indicate that will be considered in accordance with.
In accordance with the law. Yes.
This is a case petitioner is the complainant, proceeding under 138, Madam. Madam may see annexure 3. While the proceeding was initiated, the notice was issued. I filed an application under 143A of NI Act.
Annexure 3. Annexure 3. 2.
Annexure 3, page 16, Madam.
Okay. 316. Yes. Yes.
But though my prayer was to give at least 20% as the statute provides, but the state was pleased to allow 5%, 1,70,000.
You are the complainant.
Yes. Still, my lord, I accepted. Yes, give me something at least for my survival. And my lord may see page 18.
Yes.
That hence the present petition is partly allowed. Accordingly, the accused person is directed to pay interim compensation amounting to 1,35,000, 5% of the total check amount, 27 lakhs.
So you want it should be 20%?
No, my lord. I want at least that amount to be paid, my lord. This order was passed on 26. That
is also not paid. Huh?
No, accused.
Accused is not. Warrant might have been issued.
Warrant
might have been
Warrant was issued. He was arrested. He released on bail. After released on bail, again an application of 205 has been filed. In one way or other, he is delaying the matter. In between, court directed for trial. But that amount, court is not taking any steps for realizing that amount. The order was passed.
Now, what step is contemplated under law?
Well, at least
land
state-
revenue.
Yes, but let me direct the by magistrate at least to pass some order because he is appearing.
No, you just for the knowledge sake, you tell me if these kind of orders are not complied. What is the remedy?
Execution case to body.
What is the remedy? I am just asking.
Well, let me see. Last 2-5.
The warrant is issued. You will escape. What will you do?
But let me see. Page 35. Accused is absent. Represents through his counsel. 205.
Warrant to be sued.
Time is allowed.
And if that is done, then the complaint will be delayed.
No, my lord. Hard time is allowed for hearing.
Is there any provision under the act?
No.
To draw presumption?
No steps is taken by the accused. However, put up on 20 payment of interim compensation and hearing.
नहीं दे रहा तो नहीं दे रहा क्या करो?
My lord, please say a warrant may be issued, and on payment of this, at least this amount, he will be released on bail.
That I can't.
At least, my lord, in one way or other, they are defying the order.
Suppose he will be in a position not to pay the amount, and he will remain in jail for 1 year. What will happen?
Well, then what is the intention of the legislature?
That's why you assist me how to enforce these kind of orders.
The statute is not clear about that, my lord.
That's the whole difficulty.
Statute, I was verifying, my lord. And in between what he did, my lord.
What is the non-compliance of these orders? What will be the remedy?
I was going through in detail. 143A.
Here. 350. Here. Is it equivalent to 357? Your piece 350.
My lord.
357.
Let it be on day after tomorrow, my lord. I will,
1 minute.
There should be an order in this respect.
You come to CRPC.
My lord.
CRPC.
My lord.
Is it equivalent to 357 compensation?
To direct.
And what is the remedy for 357 violation?
Warrant.
Yes. Order to pay compensation.
My lord. Here, my lord, power to direct.
Court impose sentences, fine or so and so. And this is the interim compensation equivalent to kind of
357, my lord.
No, yes. How will you enforce it?
Be taken off. So a day after tomorrow, I will enlighten and there is an order.
No sentence can be passed. And you say that arrest warrant, then I am asking for arrest.
I will
only in
it's a
warrant.
Point should be decided by my lord.
Yes, you tell me now.
My lord.
Otherwise, see, this interim compensation, I say that I will not pay. Do whatever.
Do whatever you like. Day after tomorrow.
So you have to bring 357.
I will bring all the law on the subject.
How will you execute it?
Well, I will do it.
And here, remember, he is not convicted so far. Trial is still going on.
Interim compensation.
That is the interim compensation. It is only an interim compensation, not even convict. Innocence of presumption still operates in his favor.
It is to be seen why this 143A, which was not there in the statute, was incorporated in the statute.
The legislature have not contemplated this situation. If they don't pay, what will happen?
It was incorporated by Act 20 of 2018 on 2/8/2018.
I know.
It was not there.
148 also. Likewise. But 148 situation is different. In 148, because conviction is there. There is a conviction order. You can impose that sentence. Execute that sentence.
143 and 148.
143
both the sections have been were inserted on 2/8/2018.
That's right. 148 you can enforce because there is a sentence. If he doesn't pay, then execute the sentence. But in 143, what will you do?
Now, what was the intention of legislature? I'll let me.
43A 5.
5? That's what I'm looking at this. Interim compensation is payable under this section. may
They
be
recovered as if when you were appointed 421.
That's it.
Now that is
421
421.
and 457 also. Yes, 457, just
357.
357 I say.
Valid. So modus operandi of 357, that is to be seen also.
Yes, 357, that's what I'm saying. Just see 357 and tell me. Yes.
Whether the 421
Please see.
deals with warrant for levy of fine.
Please.
So on Monday,
Yes.
it will be better.
Yes.
So some
Get some judgment in that.
Valid, yes.
May I please adopt?
Yes.
Petitioner has filed a petition under section 311 of CRPC to
Yes.
recall the EW 5, 6 and 8.
5,
For
6
the-
and 8?
5, 6 and 8
Yes.
for further cross-examination, my lord.
Yes.
Due to lack of information from accused side at the time of their examination, my lord, some questions not been asked to the
Who is 5, 6?
5, 6 and 8, my lord. 8
Who
is the victim, my
Victim
lord.
is 8.
8 is the victim, 5 and 6 are father and mother of the
Mother and father. Yes. Yes. What are the offenses?
offenses, my lord. 376 of IPC and section 6 of the POCSO Act, my lord. Due to lack of information from accused side.
Where are their evidence?
My lord.
Where you filed their evidences?
My lord, questions are.
Question, if you show me the evidence, I have to look into that evidence. And whether these questions you have already asked or not, how would I know?
These
Counsel
questions
for the
are
petitioner,
after the
he
accused
can then move to file the deposition of PWs 5, 6 and 8. This is the matter of 2 weeks. Yes.
57.
May. 76 POCSO mail. Custody since my lord. 14/2/2024.
50?
14/2.
Okay, 14/2.
2024 man. 1 year already. And in the meantime, my lord, victim has already been examined. And there are 2 incidents, man. First incident happened 1 year ago. He has not stated anything about the date, time. Second incident of your lordship, for the sake of argument, concealment. It is an attempt to rape. At best. For which he has lost the affair.
Yes.
Third paragraph, your lordship.
Third paragraph.
2 paragraph.
The
paragraph
second paragraph is regarding
relating to 1 year back.
1 year back. And the
Third
second
paragraph is the for which she lost the affair.
2 can attempt to commit.
Already
medical examined by the police.
examination.
What is the age now?
16 plus
17 years.
17 वर्ष का 18 वाला 17 लीजिए लगी
17 years.
17 years से लगी ना already 1 year custody your lordship last page.
My lord.
And who is PW2?
PW2 is my mother.
The lordship had, may I please, my lord? I'm for the informant. The lordship had heard this matter twice. As it is apparent from the FIR that it is a repetition of the crime on the niece. It was on the first date, it was submitted that they are in relationship. I
No,
brought
no,
to the
I
lordship's
never
notice
submitted.
that
they are related. The first attempt was made taking the advantage of the girl trusting the man because.
What is the age of man?
35.
35.
No, that's the problem. That's the reason I'm.
Yes, that's the reason your lordship.
Your lordship has last occasion going to allow bail application, but somehow.
Then you are 35. See, there is a distinction.
Yes, your lordship is right.
Exploitation.
Yes, and concern.
If a boy is 20,
your lordship is
nearby
right.
age, it is not an exploitation.
Your lordship is right, but 1 year.
If the man, the accused is senior, then.
Yes, my lord. Your lordship is right, madam. But my humble submission. Second incident only attempt. And
I know that there you have a point.
1 year already custody.
Attempt was not fulfilled, my rape was not fulfilled because of the arrival.
Attempt was
Not
there. Parents were there.
arrival of sister, my lord. Otherwise,
Or otherwise, your lordship, the.
How many witnesses are there?
Mother came. No, there is no.
How many witnesses? Charge sheeted with.
Charge sheet witness. ସେ ତ main ଦି ଜଣକୁ ଗଲେଣି ଆଉ.
ଦେଖିବ କେତେ
ଅଛି.
see how many witnesses?
ମୁଁ ଦଉଛି. ଅଛି. Charge sheet witnesses.
Get a report from the trial court. This case.
26 ଜଣ.
Get a report from the trial court.
ସରି ଯାଇଥିବ ଆଜ୍ଞା. ଆସିଲା ବେଳକୁ ସରି ଯାଇଥିବ. Once I'm tried.
I'm giving 1 week after. Let it come. See, how many witnesses are examined? See, your age is problematic. Let us see.
4 witnesses are examined as per my instruction, madam.
Let us get a report. Okay, get a report. Huh? Yes. If the age would have been little less, I would have granted.
Last occasion, your lordship has.
That's the whole.
But my humble son, 1 year attempt. Victim has already been examined. I have withdrawn the application before that, my lord, since the victim has not examined, my lord. And
I believe you don't want to withdraw now.
Withdraw bail.
Let us see how many witnesses have examined. I'll just see other witnesses and try and give.
Next week.
Yes, yes.
Next week.
Yes. Date will be good, don't worry. 60? Yes.
20B2C, my lord. Nothing has been seized from the conscious possession. FIR 10/6/2023. This one was arrested after 6 months, 11/11/2023.
Must be absconding.
Because 2 persons were arrested, they stated that in front of the house of the present petitioner, they stored a huge quantity of ganja, and subsequently they were arrested.
Custody since?
Custody 11/11/2023. Only charge has been not framed. Your lordship last occasion observed that if 1 year has already been completed and no witness has been examined.
your lordship may call for a report. Because 500 some more.
500. What is his role?
Rule, my lord, in front of his house, my lord, there is a huge this ganja and ganja was my lord was there. This petitioner along with two are there in that talking. By seeing the police, this person was fled from this spot, and the other 2 persons
Arrested after.
And they, on being asked, they told that this
Trial court, call for a report. Okay. Yes.
Lordship call for this start.
Call for a report. Let us see what the trial says. Yes. Next.
More than a year, your lordship may 1 week after us.
500 kilo.
500 kilo. But your lordship, while disposing this bail application earlier, also observed that if 1 year in the meanwhile inside the court.
I know. Therefore, I will want to give you advantage of Ravi Prakash. If the trial is getting delayed, then
no, only charge has been.
Let us see. Yes.
64 may legal.
Yes.
My lord, the 7 petitioners are in custody since 18/3/2024.
Item 60.
60.
60 has been answered.
My lord, that which matter, my lord? I am 7 persons. We have no role.
I have urgent that matter. When?
My lord.
There is
Urgent. Huh?
My lord.
Status report.
Along with that.
My lord, status report is there.
Each along with that. Huh?
Status report is there, my lord.
No. Recent status report.
My lord, in my case, my lord, absolutely there is no material.
They were also saying the same thing.
My lord.
The other councils, while arguing that
yes,
matter, they were also saying same thing. Absolutely nothing.
My lord, the main accused, Sunil, he has not filed any petition before your lordship. We are 7 persons. Only allegation against us that while Sunil was in police custody, He confessed before police, before two witnesses. That such and such.
I have asked for a status report. What is the stage of the trial? Double murder.
My lord, already status report already called for, my lord. 7 witnesses are examined, my lord. The evidences of witnesses are already filed, my lord. Seven witnesses are already examined out of 45 witnesses.
See, the other co-accused persons matter, I have already put it after 1 week. So therefore, I want to hear both the matters together. That's the idea.
My lord, next week, my
Next week, yes.
next week, my lord, connecting with the item 16.
Yes.
65.
Obliged.
5 lordships. It is a earlier application was disposed of because non-appeal part of the petitioner liberty was given renew after the trial court.
After?
After the trial court renew your prayer once again.
Huh?
Once again.
Renew the prayer after what?
One. Prayer only says that renew your prayer. Nothing says. Due to non-appeal of the part of the petitioner.
Whenever renewed.
Lordship,
25/9/2024 rejected.
Lordship.
When you have applied?
Renew lordship.
Next day.
I am date lordship 4/1/24.
Yes.
Your lordship, as per the statement of the witnesses and as well as the victim, they admitted that since 2 years they are love affair each other.
Show me that.
Lordship, the charge sheet itself speak that. Page 20, lordship. Page
You are
20
appearing
from the-
for the victim?
Okay. Page 20, lordship, from the last lordship.
20?
20. From the invitation part, last word, the accused, last part.
Read 164 statement. Forget.
164 statement.
164 statement. Call for CD. You have 164 statement with you.
Well,
Anybody have? Do you have?
the statement and he is next to AC lordship.
376.
Lordship, they admit that the statement 161 and all these things. She and father of the victim all stated
Just
that.
I want to see 164.
Once 161 mo pagar achi.
164.
Next week I will obtain the.
Then counsel for the petition state.
Next week also I will update.
Shall place on record the statement of the prosecutor recorded under section 164 CRPC. Release the matter.
I will obtain lordship.
66.
Item 66. In the last occasion, my lord directed to file the affidavit regarding the antecedent, my lord.
File it in record.
Yeah, right. And counsel for the petitioner seeks an adjournment to file the affidavit as directed on 9/1/2000.
Any short date, my lord.
Release the matter after 2. Yes. Next.
My lord, short date.
May I please? Custody since 16/5/2023. While they are taken into custody, my lord, co-accused statements and own confession, he was entangled in this case. Considering that, my lord, your lordship granted bail to the co-accused.
302. Yes. Yes, sir. Sibo Naik. Pradeep Sahu and Pradeep Sahu. Pradeep Sahu has been granted bail.
Other co-accused, your lordship indicated in order itself. Para 4.
Rahul
Panda
has been
and
granted.
Ramo Raulo.
Raulo, no, Rahul Panda only.
Rahul Panda.
Rahul
Thereafter, next page. Co-accused, namely Ramo Raulo, had been filed bail application so and so, which was allowed.
Yes. Ramo Raulo, Rahul Panda and Pradeep Sahu granted. Sibo Naik. Sibo Naik. Anything different than their case? Pradeep Sahu, Rahul. Material. Ready? Ready now? Are you ready now? Okay. On the request of Lieutenant Counsel for the state, release the matter after one.
Next week.
Yes.
Wait, please, Your Lordship. 68, my lord. The present petitioner is in judicial custody, my lord, since 25 January 2024.
25 January.
My lord, 25 January 2024. Initially, my lord, the FIR registered under 363 kidnapping. Thereafter, police investigated into the matter and submitted charge sheet under section 363, 366, 376, 3, 6 books and 376 2N. In the meantime, the victim also examined, my lord. The statement,
No, then
the deposition of the
376, 3 is there.
3 is there. Notice already issued. And
Where is notice? Notice has not been issued.
notice issued, Your Lordship. Last order
You are appealing?
appearing for the informant.
But there is no order to that.
My lord, there is an order. I'm reading.
It's not there.
Order dated 10/12/2024.
क्यों नहीं लगा भाई? लगाए. हाँ, is there.
10/12/2024.
Is there? Yes.
Hello.
10, yes. Notice.
Issued through the
You are
register.
appealing.
Huh.
Yes, yes.
In the meantime, the victim also examined, my lord.
Show me the victim statement.
Page number 63-64 is the deposition of the victim.
63.
I'm reading, Your Lordship.
Yes. Yes. 63, huh?
I'm reading, my lord.
PW2.
PW2, the victim. I am the victim of this case. I know the accused, the present petitioner, who is my co-villager. The alleged incident occurred 3rd December 2023. That was a Sunday. On the fateful day at 11 a.m., I had been to outside for attending call of nature. The accused forcefully kidnapped me and with a bolero took me to Balangir railway station. From Balangir railway station, he took me to Bangalore by train. At Bangalore, the accused kept me in the rented house of one of the co-villager. The accused kept me for about 1.5 months at Bangalore. The accused used to threaten me and we lived there as a husband and wife. Thereafter, Belpada police rescued me from the Bangalore.
Yes.
Your Lordship, the most pivotal aspect in this
What is the
case,
age of this girl?
15, Your Lordship.
14 years.
14 plus.
What is your age?
My 20, my Lord.
Yes.
My Lord, the crucial aspect is the cross-examination, my Lord. I am reading. Presently, I am 14 years old. I have still continuing my study in school. I was studying in class 9 and I cannot say whether the accused study or not. It is not a fact. I had not stated before the police in my 161 statement and also before the magistrate in my 164 statement that accused forcefully kidnapped me. The bolero in which the accused kidnapped me, there are other 3 persons inside that bolero, apart from driver, myself and accused, but I cannot say their name. The accused along with 3 others person kidnapped me by holding different part of my body. They have not tied.
But this is the real.
Yellow.
We lived there as husband and wife.
Wife.
Yes.
Grateful, man.
Right.
And the FIR was registered on 7th April 2024 under section 307 with other offences. Later on 9th, the injured succumbed to injury. I was arrested on the same day also.
9th of
April 2024.
Yes.
But the FIR allegation is that the quarrel picked up due to a killing of a chick. There was tussle between 2 families. I have annexed 2 FIRs. Injured from both sides. They caused damage to our house. Try to outrage modesty. That is annexure 2, annexure 3, the FIR we have registered. And they have registered the FIR. Now the whole thing at least come out from these 2 FIRs.
You are granted interim bail.
I have filed that application.
Applied. Who have also received the instruction that the accused death is.
Then we are allow it.
My lord, that is, in fact, I was not saying that thing. Lordship may see what was the date for listing of that case.
We should have mentioned it.
My lord, the office is repeatedly saying it is the direction go by serially.
No, serially interim. What are you talking?
That
Serial interim bail and somebody died. Somebody died. And that's what I was wondering. You should have come and mentioned.
My lord,
Last right of your mother.
gone, already gone.
Then That's your problem. You should have come and said that last right is there. I have issued notice for verification. I put it.
Yes, ma'am.
For 13th one to
I have, in fact,
you didn't come. Other matter you come generally. Your client might not have instructed properly. That is the reason.
Well,
Otherwise, you would have come and mentioned. In other matter, you just come and
having the order, what should I say?
No, don't tell. You see, you know the pressure. If it is interim bail, you should have come and mentioned. That's
why I am not
interim
pressing
bail.
that, my lord. That's why I am not pressing.
Yes.
And so far as the documents are concerned, my lord, I have also supplied, since it was not with my learned friend who was appearing for the state on last occasion, in spite of 3 adjournment or 2, I have supplied on 21st January 2025. Now, what it reveals from the 2 FIRs, my lord, there is a quarrel between the families. And the reason is being...
If the my learned friend is not placing the internet, then you come next week.
Why? Why next week?
Impression that
Sir, your impression, what I observe, you are under a impression.
Let us see the charge sheet. Let us see the charge sheet. Oh. What are the allegations there? Yes. Show me the charge sheet.
Well, charge sheet, I have solved them. It is the certified copy.
You have to place it.
Yes.
Place it on. You place it in record. I'll.
That is also on record.
No.
Already filed.
Where is that?
That must be.
It's not
Already
there.
record, my lord. Immediately after the last date I have filed and solved the copy. Had it been an ordinary 302 case, I would not have.
No charge sheet is not there. That is not. They will file it, you will scan in your. No. It's not. Reach it up next week. You got the CDS? Yes.
Must say
Next. Yes, next 70.
Again?
70.
Next week, sir, ଆପଣ ଯେମିତି କହୁଛନ୍ତି ନା ଦୟା କରୁଛନ୍ତି ଏଇ ଜଷ୍ଟ ଆପଣ ପୁରା ସେଇ କୋର୍ଟ ସାଇଡକୁ ଯାଇଛନ୍ତି ସାର୍ କାହିଁ ଏମିତି ହଉଛନ୍ତି ଅବଶ୍ୟ ଆପଣ ଦେଖା ଦଉନଥିଲେ କୋର୍ଟରେ
May I please your lordship that I have been in custody since 7/9/2023. I have been charged with 363, 366, 376.
70 କରୁଛନ୍ତି
transfer.
ଆଚ୍ଛା
My lord, I have been
ପ୍ରିଜନର
charged.
ପିଟିସନ ଟା ଆସିଛି ଯଦି କରୁଛନ୍ତି
ଆଜ୍ଞା
ମାନେ the
Prisoner has given a
so that the prisoner has some petitions.
You have also filed.
No, my lord. I am filed the case. Notice has issued to the informant. Now it is noting that there is a prisoner petition. Therefore, my friend is appearing and arguing.
Anyways,
Obliged. My name may be deleted.
Yes. Thank you.
My lord, I have been charged with 363, 366, 376, 2N and POCSO 6. In the meanwhile, the charge, I have been in custody since 7/9/2023. In the meanwhile, charge sheet has been issued and the victim and as well as her mother has also been examined. I have given a copy of that. So I refer to the page 37.
Yes.
Page 37 of my petition.
Yes.
That is a para 5.
37. Yes. Para 5. Yes.
Para 5. That I
stayed
stayed with the accused for a total period of 1 year from the date of leaving the house. Then I will refer to the para 2. Page 36, para 2.
I read don't read one line.
Achha,
and the date on which the accused deserted me at Sambalpur. And in Sambalpur,
and the date on which the accused deserted me at Sambalpur. At Sambalpur, we used to stay in the house of the Pintu. But I cannot say the locality at that house. My lord, after that, subsequently, it is not. I wanted to say that she stayed with me for 1 year. And after that, para 2 of the page 36. Para 2 of the page 36.
Yes.
She is telling the alleged incident occurred about 1 year ago. The accused Tanu Chandra seduced me and with a promise to marry me and live in as husband and wife.
Yes.
both of us lived as a husband and wife. After that, my lord,
What is the age of this girl?
First took me to Kesinga,
17.
kept me there for 15 days.
17. He is the man. 35.
Actually, victim's mother has given a declaration, kindly page 35.
35.
Para 5.
Yes.
I had no direct knowledge regarding the incident. I cannot say when the FIR was lost. Approximately after 6 months after return of my daughter, FIR was lost. My lord, because she stayed with me for 1 year. There was no complaint. She came back to her parents' house.
You serve the victim.
Yes.
Because 376. Right? The victim and informant. We served through the IIC of which police station? IIC of Titlagar. Okay. Please the matter. Yes. Sir, then.
71.
The mother has not supported. The only problem is 35-year-old and the girl is 17 years.
My God.
Please, your lordship.
Yes, 70?
71.
Yes.
Please, your lordship. The case under section 30201 IPC. The charge sheet has been filed. And in the meanwhile, my lord, 9 witnesses have been examined. And since 5/1/24, the petitioner is inside jail custody. The case is based on the circumstantial evidence. There is no direct evidence. My lord, the page 24 may kindly be used.
Custody since?
Custody since 5/1/24.
5?
5/1/2024.
Okay.
My lord, in the charge sheet, the IO has page 24. The IO has mentioned after publication about finding of dead body, Vishnu Prasad, the main suspect, namely Dasia and Sikanta Behra, committed suicide by hanging from a branch of a mango tree. The main suspect, main accused is Dasia alias Vishnu Prasad. The present petitioner is not the main accused. Only he confessed before the police and gave recovery of the some weapons and the witnesses to the recovery item.
Yes. Huh? CD. Okay, call for CD.
73.
307 along with other offences. Custody since 2011-24. Charge sheet submitted 22/3/24. And so far injured is concerned, my lord, 2 injured is there. One injured is Nilanchal Das and another injured is Sunyavasi Das.
Yes.
They have not disclosed my name, my lord. The petitioner is in custody, my lord, since November 24.
Yes.
I have read out the statement, my lord.
How it has come to me?
Earlier, your lordship allowed the application of co-accused.
Yes.
Injured statement I am reading, my lord. That Mu Sunyavasi Das, Ita Bimo Das Misi Amogramor.
Your name is Ranjan Das.
Yes, madam. Nilanchal Das one injured and Sunyavasi Das is another injured. They have stated ଯୋଜନା ମୁତାବକ ପୂର୍ବରୁ ସେଠାରେ ଠିଆ ହୋଇଥିବା ଆମ ଗ୍ରାମର ବଂଶୀ ଦାସର 3 ପୁଅ ଜିତୁ ଦାସ, ବିଭୁ ଦାସ, ନିରଞ୍ଜନ ଦାସ, ରବି ଦାସ, ବାବୁ ଦାସ, ପ୍ରକାଶ ଦାସ, ଅଶୋକ ଦାସ, ପିତା ଗଗନ ଦାସ, ପୋଡା ଆଲିଆଜ ଅନିଲ ଦାସ, ପିତା ବିପ୍ର ଦାସ ସମସ୍ତେ ଏକତ୍ରିତ ହୋଇ ଆସି ଆମକୁ ନଥିବା ଭାଷାରେ ଗାଳିଗୁଲଜ କରି ଆଜି ଏମାନଙ୍କୁ ଜୀବନରେ ମାରି ଶେଷ କରିଦେବା କହି ସେମାନେ ଲୁଚାଇ ରଖିଥିବା ବୋମା ଖଣ୍ଡା ଆଣି ଆମକୁ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଆମ ଉପରୁ ଲଗାତାର ଭାବେ ପକାଇଲେ, ଯାହା ଫଳରେ ମୋର ଡାହାଣ ଗୋଡ ସମ୍ପୂର୍ଣ୍ଣ ନଷ୍ଟ ହୋଇଯାଇ ଶୂନ୍ୟବାସୀର ବାମ ହାତ ଗୋଡ ଦେହରେ ମାଡ଼ ବାଜିଛି.
You are Ranjan Das.
I am the Ranjan Das.
You and Nira Das pelted 2 number of bombs.
But the injured has not stated my name, my lord. That is the The injured statement.
There is a case. There is a kidnapping, one Sushant Das. Thereafter, the accused person injured two injured persons. There are three victims. Sushant Das was kidnapped by the present accused person. His 164 statement is already recorded in action. I read that 164 statement of that.
Sushant evidence is recorded.
Yes,
Has been
sir.
recorded.
He is not the injured, my lord.
Whatever.
But it is clearly stated that the name of present petitioner is very much present and he is
Injured might not have seen you.
No, he has
You have
who
thrown
has
the bomb.
support, my lord, and he has hell and hat, my lord. A report may be called for my lord. No, किसी नष्ट ही नहीं है.
Yet not been received. As per the impugn order lordship, kindly glance the impugn order.
What is the stage of the trial?
The trial not commence, my lord. He is moving in the village. Hell and hat, my lord.
But it will kindly glance the impugn order lordship. The learning report is clearly mentioned that not yet received the injury.
And co-accused you of granted bail.
Ask for the charter. Trial charter. Trial.
Injury report may be called for. There is no such injury, my lord. But he is moving in the village. This is the photograph of recent photograph. No, godo lage injury report down no.
Anyway, I call for the charter. Yes.
Lord, short date may be given 307.
Yes. I have earlier rejected your bail.
No.
Also, I gave bail to the other people.
He has not approached, my lord.
In that bail application, your name is
Not absconded. He is moving in the village.
Anyway,
He as per my since charge sheet submitted, he has surrendered, my lord.
Okay, 74. Yes.
74, my lord. I have filed a IF for modification of order, my lord.
Which one?
27/1/2025.
What modification?
My lord, this is a bail in the nature of Belgium, my lord.
Hmm.
And last occasion, your lordship was pleased to quash the NBW order, my lord. But in this case, my lord, NBW order has been executed and petitioner is in custody, my lord. So he may be released on bail, my lord.
Then remedy something else. Modification, how I will. You ask for cancellation of NBW, I cancel. By the time it is cancelled, you are arrested. What to do?
This is a bail application, my lord.
Okay, this is a bail, okay.
Yes, my lord, bail application.
So why are you seeking modification then?
Because NBW already been executed and petitioner is in
This
custody,
is
my lord.
439 or what?
439, my lord. 430.
So why are you saying modification? I thought it was modification.
My lord.
Yes. In the nature of modification.
Yes, my lord.
Okay, come, let us see. You were on bail.
Yes, my lord.
Earlier he was on bail. So he has to be granted bail. I know. Earlier bail order, show me. Show me earlier bail order.
That is there, my lord. Yes.
That is there, show me, that's what I'm saying.
Bail order is annexed there, my lord. Page 16, lord, you may kindly say.
16:16.
Page 16, my lord. Page 16, here it is mentioned that further the accused petitioner was released on bail.
Where is that? Page 16.
Page 16.
Here is the record.
Yes, my lord.
The bail petition of the accused petitioner was rejected on earthly. And this
1, 2, 3, 4.
bail application filed by the petitioner.
1, 2, 3, 4,
It
5,
remains from the
6,
record
7, 8,
that
9, 10,
so
11, 12 para, my lord, from top.
Yes?
12 para from top, my lord. 12 line from top, my lord. Further, the accused petitioner was released in view of the Honorable Court's order, right, BLAPL number.
Right, petitioner was already admitted to bail in the present, and a petitioner is accused in so and so case. Petitioner was already admitted to bail by this court by the order dated 5/12/2023 in 23 in BLAPL number 22-163 of 2023 must be 2013.
2013, my lord.
2013. Because of his absence from the court, the trial court issued NBW by order dated where is the NBW order? Order dated 30th September 2015. The petitioner approached this court seeking quashing of the NBW order. This is the order passed here, which you are relying upon, is passed in BLAPL number.
BLPL.
Huh? 343. Was it
Yes,
a
ma'am.
BLAPL or
BLAPL.
criminal MC?
BLPL.
How was the bail bill is maintainable after extension
Within custody.
I am not with the brief or whatever, but I is here with me.
You just tell me when your NBW was cancelled, what you had to file.
My lord, I'm saying, my lord, NBW issued on 30/9/2015.
Thereafter, what happened?
Thereafter, thereafter, petitioner was taken to custody on 24/4/2024. NBW executed, petitioner was taken to custody, my lord. Thereafter, I have filed BLAPL, my lord, after custody, my lord.
Which one? Which BLAPL?
BLAPL number 343, my lord.
343.
343.
There, this order was passed.
Yes, my lord. 343. Well, it wrongly ordered, my lord, in this wrong.
Then you should have asked for correction.
Yes, my lord. That's why I have filed IA, my lord.
Huh?
That's why I have filed IA for correction of order, my lord.
I just not able to follow what you are asking.
Lord, may I assist, my lord?
Please assist me. I am not able to follow.
My lord, my lord, NBW was issued by the Lalat trial court. He was taken to custody pursuant to the execution of the NBW. Thereafter, he moved a bail application before the Lalat trial court.
Yes.
That was rejected. Thereafter, the petitioner approached your lordship for release.
That much I understand. What is the order dated 27/1/2025?
27/1/2025, my lord. That order has been passed like an Belgium matter.
So that is what I'm asking. Then this he should have asked for modification of this order.
Modification. That's why he has filed the IA for modification.
This is a modification or bail application?
Modification, my lord. Modification in your lordship passed order dated 27/1/2020.
That's completely wrong order then.
Yes.
Yes, my lord.
You should have said that.
Yes. This is a wrong order.
I am reading that saying that cancellation of bail.
That's why, my lord. Your lordship may be pleased to direct for his acknowledgement, my lord.
Right. You should tell that this order is completely wrong.
Yes,
I am relying upon that
wrong.
statement. Yes.
Sometimes we do not muster courage to say that your lordship's order is wrong.
No.
That is the whole difficulty.
Everybody commits wrong.
Grateful, my lord. Grateful for your lordship's magnanimity, but as a junior counsel.
No. Everybody commits wrong. This is the wrong order.
Wrong order because
you simply
this
say that
order lordship usually pass when the accused is outside.
Yeah.
Grateful, my lord.
Because of his absence from the court, the trial court issued an immediate high order. This is not the petitioner uploaded his court seeking person with the immediate order.
The NBW was executed and the petitioner was taken into custody on
24/4/2024.
24/4/2024. Thereafter, the petitioner moved the present bail application. Bail application. In the said, when the matter was taken up on 27/1/2025, inadvertently the following order was passed. 27/1/2025. It appears that the order, the aforementioned order was passed with an impression that the petitioner is seeking cancellation of NBW issued against him. But in fact, the NBW issued on 30th September 2015 was executed and the petitioner was taken into custody. Hence, he applied for regular bail. Therefore, the order dated 27/1/2025 passed by this court is apparently an erroneous order. Erroneous order. Let a counsel for the petitioner submits that the petitioner is already was already admitted to bail by this court by the order. So. Therefore, after the execution of NBW, the petitioner, when the petitioner applied for bail, the court should have taken into consideration the fact that this court had admitted the petitioner on bail. However, ignoring the same, the petitioner has been remanded to custody. Hence, he has approached this court. Regard being had to the fact that the petitioner has already been admitted to bail by the order dated so and so by this court, and due to the default by the petitioner to appear before the court, NBW was issued, and on execution he was taken into custody. I'm inclined to enlarge the petitioner on bail with the condition that the petitioner shall appear before the trial court on each date of hearing without fail. Even in one occasion, if the petitioner failed to appear before the trial court on a trial court during the trial on any occasion without being represented by the counsel or otherwise, the concession of bail granted by this court shall be recalled. Okay, with this condition, and yes, granted. Yes.
75.
The defects have been pointed out. This can be ignored by your lordship. Defect number 2 is the delay shown, which I have already filed consideration of delay petition.
What is the delay? Number of days?
Number of delay 1946 days. 1946 days. I have
1940.
Yes.
60. Okay.
And the single judge.
Let us come to that application. What are the explanation you have offered?
It was dismissed by a peremptory order.
Delay of 5 years, 104 days.
Yes, madam. The certified copy of award was filed late, and the matter was peremptory order was passed, which we could not know that it was a peremptory order. We filed the certified copy, but the matter was disposed of, dismissed in the registry. And when the insurance company further pursued the matter, we on the High Court portal, because at that point of time we were not able to verify the matters regularly as we are doing presently. So it was not within the knowledge, and matters were not also getting listed regularly.
Yes.
Situations have improved. That is, your lordship may kindly consider.
You are the insurance company?
Yes.
Yes, forget. Insurance company, these are beneficiary legislation, some compensation is paid, and you are so casually prosecuting. You are I can understand an individual.
No, claimants are
5 years, 100 days. How will you explain the delay? You are an institution.
Claimants are not going to be deprived of the that award. Your lordship can direct the deposit of the award. They have also initiated the certificate proceeding in 2023, not before that.
Maybe that's a different story. I will dismiss on the ground of delay, and let it be, yes, ground of delay.
Your lordship may kindly consider.
I could have considered if the individual should have come. It's the insurance company. Insurance company is saying that we had no knowledge. Then why are you prosecuting? Leave it.
Sometimes
no, these are right.
Mistakes happen. Your lordship may kindly consider this.
Leave it. If insurance company, why should I? Yes, right on. Petitioner is agreed by the order dated. Where is that preemptory order? Yes. Agreed by the order dated 31/8/2015, passed by the court in MACA number 234 of 2006. For ready reference, the order is reproduced here in under. Right on. As a as a last chance, the learned counsel for the appellant is granted 2 weeks time to file a certified copy of the impugned award, dealing which the appeal shall stand dismissed without further reference to the bench. The after this peremptory order was passed by this court, the petitioner had not taken any step. As a result of which the petitioner, the appeal, the MACA case stands dismissed by the stand dismissed. The petitioner has now filed the application for restoration of the said MACA case. The restoration application is suffering for a delay of 1946 days, that is 5 years, 100 days. To explain the cause of delay, the petitioner appellant has filed an application under Section 5 of Limitation Act, inter alia stating as under. Para 2, IA number 59 of 2021. ठीक है? Para 2 to 5. 2 to 5. 5. तापर जो judgment को लेके sufficient reason वाला the application for condemnation of delay is dismissed. As a consequence, the CRLMP is also dismissed. Yes. Next.
76. Part of mistake was also on my part. So,
all right.
May I please?
Company, yes.
The case notice has already notice. I have filed the notice. Late, I have filed the notice. In the case.
Late
filing of the requisite, accept and utilize the same for the service. Yes.
So far as your lordship says, the review petition, there is one defect. They have shown SR as shown a defect. I have challenged the order dated 22 to then before the writ appeal, and certified copy I have filed in the writ appeal.
It's all right. I'll ignore it. First, sir.
That may be about your lordship. That
77.
defect.
Yes.
77. This matter.
Yes, sir.
Previous CMPL 231 of the 2016 was notice to the opposite party. 235 one insufficient. In that case, I've filed a second time. But due to the other court, I have the other court, the case is dismissed. After that, I filed the 114 of the 24 for restoration. That case was dismissing due to the other court. I was could not attend that he was busy in the another court. This is the cause of this case. My submission that to notice to the opposite party for the rest of the RSS secondary 67 of the 67. Rest of the.
What is
my submission that my case is that Mondadhara mo case would degree by this jagare. What are ghar
You go systematic way. You are talking everything at a time. How will I?
After 15-1 of the OSP Clark case, my case number my 1640 of 99. This case was decreed in favor of me.
This is no way submitting. You tell me what is your case.
My case is such notice of
you are
rest of the once
your application for restoration is dismissed.
Second appeal dismissed for default. That was filed in CMPA.
That is also dismissed. That is also dismissed. And a very reasoned order dated 28/8/2024.
My lord, first example is the notice to opposite parties. 235 only insufficient. 235. 1 notice sufficient, 4 notice sufficient, 6 notice for sufficient. Only 235 insufficient.
If I am not wrong, what you are trying to say is,
my lord,
your second appeal dismissed for non-proceedings. You moved an application for restoration. That application is number 231 of 2016. That is also dismissed in default.
Dismissed default. First notice is issued of
1 minute, dismissed in default. Then you move an application to restore that.
Second.
That application is also dismissed.
Dismissed.
And now you are filing third application.
No, my lord, recall of the order of the recall. My lord, because of the order of recall of the second application.
Just see,
Recall.
just see the
Because
order.
of kind of you have to
Just see that order is very clear.
same court pass करते same court आगु थोड़े simple order करते ले notice को तो opposite party same court second sample ले dismiss कर ले गांव रो जे other court में busy थी बोली it actual separate old court and new court
The first when first CMP dismissed that day also you are busy.
No, first sample
And when second appeal dismissed that day also you are busy.
second sample total notice है नहीं second sample total notice है नहीं second sample total notice है नहीं.
This is unnecessary wasting time.
Second sample notice है.
I don't think it.
My lord, advocate name is not there. Second sample. My name is not there. Case dismissed.
All these things will not work. Yes. Yes, anything else? Repeated indulgence can't be given.
My lord, advocate name is not there. My name is not there. Only advocate name is written.
What happened when your second appeal dismissed? Second appeal dismissed for non-prosecution. Restoration application dismissed for non-prosecution. Thereafter again you move application for restoration of restoration. That is also dismissed in non-prosecution. And now you move application again, fourth application.
My first
put an end to it.
You notice to opposite party. Second restoration without notice to the opposite.
It's not necessary. If you have not satisfied the court, what to do?
My lord,
am I bound to issue notice? If you have to satisfy me, then only I will issue notice.
My lord,
otherwise I dismiss it.
Notice from the my lord. Notice dated 235 notice 235 point. Notice with days, my lord. 235 and notice.
I think you are not able to follow. I'll put it after 2 weeks. You please prepare properly and tell me address. You maybe you are saying something which I am missing. Date chart would bane kya Okay, Monday. Date chart bane kya maybe you are telling something I am missing it. Maybe I don't know. I have understood the way the order is there. Yes. 78. आप डेट चार्ट लिखिए केबे कोन होइतला ठीक अछि yes yes
item 7 on behalf of Mr. Gurudata Kara filed the CMPL for distortion of OJC number 6585/1998 for this
delay. How much delay?
2110 2110 that time senior father
2093 days
2093 days at the time my senior father senior advocate Prahlad Kara bedridden and she died on 1/12/28 2018 so is it
you have not said anything. When the conducting council expired?
1/12/2018.
1/12/2008.
1/12/2018.
1/12/2018. Yes. Then when it was filed?
He was completely from
That's right.
Before was bedridden.
And 18/9/2024 it is filed.
There, after getting this dismissal order, the other side created some problem there. Then they
no, but the cause you are trying to show is just see. When the matter was dismissed on default, that is on 26/11/2018. November 2018 dismissed in default, and the conducting council died on
1/12/2008.
1st of April 2018.
1st December.
1st December, no, yes. 1st December 2018. And you have filed it in 2024, November 20. 2018 onwards, there was no one.
No, because they are not coming. They are not inquiring. Nobody was there knows about this dismissal. Nobody, because everybody is busy taking care of this senior minor. He died at the age of 93.
Oh, he died in 2018.
My lord.
Why have you waited for till 2024?
There was a peaceful communication.
I'll issue notice. Let them the other side come. Huh? I'll issue notice. Issue notice on the condemnation of delay. Condemnation of delay. Okay.
But it's a very genuine ground.
That's right. I understand. But let the reply become. Okay. Restoration of what? By the way, this is OJC. Is there anything remain in that OJC?
Yes, ma'am. Yes, ma'am.
What is that?
That is because two courts has given view in our favor. This is a tenancy act based upon tenant. We are continuing with the possession. Still, we are continuing with the possession. And they are, after knowing this dismissal, they have started creating.
You are the tenant.
I am the tenant.
So how many years you will stay? A tenant is a tenant always.
You
can't be the owner.
They have accepted the rent from us. That is continuing. After this, it has.
Is it a perpetual tenancy?
Oh, yes.
You are claiming a perpetual tenancy. Nothing is there in the main matter. You have to vacate. Today or tomorrow you have to vacate.
My lord, that my lord will merited. I just to hold. My lord, restore it. Then after.
I'll restore it and.
My lord, fix the debt. We'll hear the matter. My lord, I have nothing to say.
But
only giving one.
Read petition by a tenant.
My lord. Only give me.
And you enjoyed 2018 to 2024, despite the fact that it is dismissed.
That is by virtue of this honorable court precedent. We are continuing. My lord is providing shelter, so we are continuing. My lord only give.
See, the court is no one to provide shelter by taking shelter from someone else.
What I humbly pray, my lord, restore it. 2 is time given. Date may be fixed. We'll have the matter. My lord will pass the appropriate order.
Let them come. You get ready to vacate. And how much money you want? Tell me.
That is a question.
In lieu of vacation. Simple.
Last from 65, I am continuing. Last 65.
So then but you are still saying that you are tenant.
But continuing, my lord, because they are accepting rent from us.
Do you have any law perpetual tenancy?
My lord, that time I am not prepared. Then if my lord will provide times.
One should be fair enough. So if the prima facie case is also to be seen when it has to be restored.
Here in the case, they are telling that it is a road. But two opinion has come from the RI and all these things. This is not nowhere concerned. This plot is nowhere concerned to the road. I am not acquiring any matter. 3 decimal land where we have constructed house from 1965. I am continuing. So this is the scenario.
Okay, I'll issue notice. Let us see.
One more thing is that 98 this is 78
That's what I asked, whether you are perpetual tenant. Ancestral wise.
Then it will clear.
Okay, I issue notice. Let us see. Let them come. Okay. But try to settle this. Yes.
I will communicate definitely that the views of the honorable court.
How much you need, you tell me. I'll put it to them and they'll pay you and get rid of you.
This government land, madam. Government land. If required, then government can acquire. No problem for that.
Let it be. But you say you are tenant. Let it be government land. How are you concerned about it? Yes.
Yeah, I told you, my lord. So above aforesaid petition dismissed.
Requisites by within 2-3 days.
Monday.
By Monday. Tuesday. Yes. Tuesday. Yes.
May I please, my lord?
Yes.
My lord, above petition dismissed due to non-removal of the defect.
Delay how much?
Lordship.
Delay.
5%.
Huh? Delay.
Removal of defect, the application was dismissed on form because they have no need to. But CMP is filed and
24.
Yes, your lordship.
How will you?
I will take your leave to.
Yes, your lordship.
Lordship, that is 1510-2000. Kindly have a glance to page 11, your lordship. It's a non-appears on behalf of the petitioner on call. Defects pointed out by the
dismissal 1510.
Yes, your lordship. On 29/11/2018, again the perimetry order has been passed. And 1510/2019, the registry has dismissed my case without reference to bench.
Yes.
This fact is not within the knowledge of the present petitioner.
Then you throw the paper in the court and you don't cure the defect. and registry will come to tell you.
No, Lordship, I bow down to that, but when
that is the only thing.
The petitioner is a
this is not
petitioner living in a remote area. Lordship is
maybe you file a writ petition.
Yes, your Lordship.
There was a defect.
Yes, sir.
Who will cure it?
That is the
lawyer
will cure it. No, the lawyers.
And thereafter you say that I don't have knowledge.
No, the conducting lawyer has not been done. Then the petitioner came to us. We have explained it, your Lordship, in our petition also. I have.
Yes, I read it.
Yes, your Lordship. That is to para 2 and para 3, your Lordship. That the petitioner number 1 is very old person having various ailments. Petitioner was looking after the case with the knowledge anybody. The petitioner after long and died.
It's not about the knowledge of the petitioner. It is the lawyer who has to cure the defect.
So see, he
petitioner,
has
old man will not come.
He has not. For that reason, the petitioner has approached us.
So this is not sufficient.
Your Lordship, we have approached her, and the valuable right of the petitioner is going to be affected. Your Lordship, section 37 application has been rejected. On that ground, they have come before this honorable court. The Consultation Act, your Lordship, the right title interest is involved, your Lordship. Then
if you conduct casually, what to do?
The conducting, I can't raise objection against
the opposite party on the condonation of delay only. Only in condonation of delay. I am not satisfied.
Yes, your Lordship. Limitation notice.
Obliged. 80.
Madam, I am for the respondent claimants, madam. In both the cases, madam.
Yes.
And may kindly be taken up in 18th or 19th, it can be disposed of. They have taken instruction. They will take the instruction.
19.
Your Lordship, there is a delay. In FAO 388, there is a delay of 58 days.
I'll consider that. If you are settling the dispute, I'll condone the delay.
On that day,
don't worry. Yes.
Your Lordship, there is a defect number 3 for a deficit code phase of 6.
Everything I'll condone if you settle the dispute. Otherwise, I'll look into it. If you are settling the dispute, everything is condoned, delay and everything. Let it be 2008 delay, no problem. If settling the dispute, I'll record it and dispute it. If you don't settle, then that's a different story. Yes.
Madam, this is the cover judgment of our High Court.
82.
With regard to 50% withdrawal of the fixed deposit amount, madam. Number of judgments has been delivered, madam. In view of the order of this
You are appealing?
Yes.
This is the original order.
What do you say?
Lordship, there is a discretion of the Honorable Court to so far the release, but they have challenged on the ground that they have been directed to open.
Why I exercise discretion? One court has already done it.
Yes, my lord.
This is the original order, madam. In view of the order, that order has been passed, madam.
Okay, relying upon this.
Yes, madam.
Relying upon this. Take it. It is relied. Where is that?
Yes, madam. In paragraph.
FAO. Huh?
Yes, madam.
FAO 2015. Call certificate. FAO 262. And batch. And batch. Title. That's not the legal. It is relied. Judgment it is done. Relevant part will be good. Which part is?
File me appearance. SS question.
Yes, Mr. Kashyap's name. Which paragraph is relevant?
Madam.
Para 9, page 12.
Para
4, my lord. Para 4, the last ordering portion, it has been reflected, my lord, in main order, my lord. And in covered judgment, my lord, in paragraph 4, it has been clearly written there.
Yes.
No.
It is judgment which you have relied upon. That is 262, which is the relevant paragraph.
I have gone through, my lord, but I will not mark this in, my lord.
What is the ratio?
This has been decided, my lord. I will mark the same and file you for it.
Huh?
I will mark the same, my lord.
You give me that part, I will reproduce.
Yes, ma'am.
From this judgment, I want to reproduce.
Yes,
para 4.
Yes,
para 4 down, relevant part I will reproduce.
Yes, ma'am.
I'll just give it at once. Para 4, yes. Yes.
Maybe
The present petitioner challenges the order dated 27/1/2023, that is the order annexation number 1.
Let's see, notice. Addressee refused. Service through IIC. Which police station?
This is Narsinghpur, my lord.
Narsinghpur PS. Narsinghpur PS.
Yes, sir.
IIC. Service of police party. IIC Narsinghpur. Okay. Lego this notice was issued 83, na? The notice was issued by the order dated 18/12/2024. However, the service is not affected, and the postal remark indicates that addressee refused evidence mark. Let the notice be served through the IAS. Yes.
During the pendency of this case, my lord, the court will issue the NBW against the present petitioner on 6/1/2025, my lord. I have filed IA, that is the 155/25.
One
155/25.
155/25 during the pendency of the present petition, the JMFC Narsinghpur, by the order dated
6/1/2025,
issued NBW against the petitioner, and she has moved the application for recalling of the same. Subject to petitioner appearing before the JMFC Narsinghpur on or before 5th of March, the execution of NBW issued on certain date shall remain stay. Yes.
Okay. 84.
Lord, for extension of time, modification, my lord, for extension of time for surrender, my lord, for the court below. Initially, my lord, your lordship was pleased to direct on submission of my lord, the petitioners, my lord, affidavit, that you will surrender on or before 25/12/2024 before the court.
The time for surrendering or appearing before the court by the petitioner is extended up till 5th of March.
My lord, ବର୍ତ୍ତମାନ ପ୍ରୋବ୍ଲେମ ହଉଛି କଣ ନା ଆମର ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍ ରିଟାୟାର୍ଡ ହେଇଯାଇଛନ୍ତି ଆଉ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍ କେହି ନାହାନ୍ତି ବର୍ତ୍ତମାନ, ତେଣୁ ଆଉ ଟିକେ ଲମ୍ବା ଡେଟ୍ ଦେବା ପାଇଁ ପ୍ରୟାସ।
ଠିକ ଅଛି। Then 15 March.
ମାର୍ଚ୍ଚ
15 yes.
ମାର୍ଚ୍ଚ ମାସରେ ଯଦି ଜଏନ୍ ନ କରିଥିବେ ପୁଣି ମତେ ଆଉ ଥରେ ମଡିଫିକେସନ ପାଇଁ ଆସିବାକୁ ପଡିବ।
Then I have to verify.
ନାଇଁ ନାଇଁ ମୋ ପ୍ରୋବ୍ଲେମଟା ମୁଁ ଏକ୍ସପ୍ରେସ କଲି।
15 March I think.
May I please, Your Lordship? My lord, offense under section 498, my lord. Notice already served, my lord.
Yes. Sufficient notice. Yes. What are you seeking?
498.
498A. Service through IH. Through IH. Service, despite service, none appear for opposite party number 2 in the interest of justice. The opposite party number 2 be served through the IIC, so and so, so and so. Yes.
86.
Obliged, my lord.
Modification extension lordship. This order passed by the IC system judge Hon'Ble lordship. But lordship kindly see para 3 lordship. Pending the court of the learned JMSC Bugra input in ADJ Bhandanagar lordship. Order ta passed by learned ADJ Bhandanagar. 3 lordship 3 para. Next lordship 6 para मध्य
नहीं जस्ट आपण देखंतु आपण पिटिशन रे कंडक्ट
मो पिटिशन लॉर्डशिप लिखि
बुगुडा लिखछथि आपण
मो लिखि लॉर्डशिप क्लास सिस्टम रे
राइटिंग ऑर्डर
बुगुडा मूल केसटा बुगुडा लॉर्डशिप
हां भंजन
एसटी ही जे एडी भंजन आशीष लॉर्डशिप
तेरे करो भैया
ए 3 परेशन अब लॉर्डशिप तापर 6 रे मत कर
3 या 6 पैराग्राफ
6 रे मध्य पास रे बात लर्नड जेएमएस बुगुडा इट शुड बी एडीजे भंजनगर अब लॉर्डशिप
एडीजे जेएमएफसी बुगुडा लिखा है जी एडीजे
भंजनगर नेक्स्ट एक्सटेंशन टाइम दरकार लॉर्डशिप
5th March
लॉर्डशिप 1 से लॉर्डशिप मते 5टा माने भी कहै जी गंजाम बार एसोसिएशन वेलफेयर भंजन बार छ लॉर्डशिप डिस्टेंस 80 किलोमीटर मो तो भंजन बार लोक लॉर्डशिप
अच्छा 500 टका पई भंजन जीवा पड़ियो
मत आई टू मूव 80 किलोमीटर्स I may be direct to deposit before the Bhandana bar. Bhandana bar. Obliged.
ଗୁଡା ଜାଗାରେ ଇଏ କରିବ ଟାଇମ୍ ଏକ୍ସଟେଣ୍ଡ କରିବ ଛାଡୁଛି ପଇସା ଡିପୋଜିଟ୍ କରିବ ଭୁଲି
May it please.
Yes. For hearing.
Yes, small issue, Lordship, I remember that vigilance case against a secretary of the cooperative bank.
But I today it's not possible.
Yes, so, my lord,
Survey copy, let it be there on the board. Let it be there. Let it be there on the board.
Any date when your lordship can fix.
Let it be there on the board whenever Monday,
Yes.
Tuesday, whenever.
Copy of the written note.
I will give.
Give, Mr. Pari has filed the written note of submission. Copy of the same is supplied to Mr. Das. Lease for fund for the.
Both
Mr.
will
Das-
exchange ourselves with the written note of submission is convenient for all.
Yes. Yes.
Let it may board, Lordship, it's not tomorrow, then
Let it be there in the board.
Monday.
It will be there on the board. Yes.
My lord, may I pray? Can it be 2 p.m. in any day?
2 p.m. See.
I know the pressure of this court.
These bail matters are coming unnecessary pending for such a long time.
Would not be possible because of registry of bail matter.
What to do? Bail has to be heard.
Yes, yes.
And these bails are not to be disposed of like
They will
this.
suffer inside the jail.
That is the whole difficulty.
Let it be board, Lordship. Yeah, pattern matter.
And the tied up bail is a big problem.
A big problem.
Big problem.
The segregated is one issue is good, but pressure to the court is different way.
No, the system is derailed because of the excessive pressure on the bail. You know, all the courts are suffering.
Yes, all the courts.
Yes, 89 appeals are pending for your lordship. That could not be disposed of because of our pressure.
Then may I pray on 20th or
let it be there in the board. You come whenever.
Because I will be absent from 16, 17, 18.
It's all right. No problem.
Thereafter, you will listen.
Yes.
No, my lord, let me board.
Yes. 88.
May I please, my lord?
Hearing matters.
My lord, directed me to obtain instruction if there has been any movement. In order to condone the delay, the lordship, the case hasn't moved. I have got the certified copy of the order sheet. It hasn't moved anymore.
No, there is delay.
My lord, 278 delays. If your lordship recalls, your lordship had directed me and Mr. Das, appearing from the vigilance, to take instruction if there is any further movement after cognizance. This is a certified copy of the order sheet that there has not been any movement.
What are you challenging by the way?
This is a rejection of my discharge petition, your lordship.
And charge has not been framed.
No. Yeah.
This release of Mr. Das is Sankar Das is
That really is not. But we both were asked to do the same thing. I have got the certified copy.
He has been entrusted with this revision.
Yes.
I am just submitting.
See.
And if you don't go, what to do? You are absent. All accused persons are absent.
My lord, the petitioner is actually.
Is there any stay passed here by this court?
No.
There is no stay. Then you don't go.
I have asked, prayed for a stay.
Now you are asking, but why have you not gone? Just see the entire proceeding.
My lord.
After your application is dismissed,
My lord.
thereafter you have not gone there.
That's what I
That is the reason charge is not framed.
No, that's the.
Is there in that? Just see. From September,
That's what I submitted on the last occasion, if your lordship recalls, that the petitioner is ailing and is staying with his son in Bangalore. That's the reason the delay in filing this revision.
6/12/2023, your application was rejected.
My lord.
Thereafter, you have never appeared.
My lord.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 days. 13 days you have not gone.
That's what I had prayed before your lordship. Your lordship appreciating that had said that get a direction whether there
No,
has
you don't cooperate with the trial, what to do?
because my
13 days you have not gone. Yes.
So that could not be done. It is delayed. Because of his absence, it is delayed. So it will be delayed again.
You can't take advantage of that delay because it is because of you. Now there is no question of stay. Now come on merits.
My lord.
There is delay also. Here also the delay.
Then, 2-3 short points so far as the merit of the case is concerned, Your Lordship.
Yes. Delay of how many days here?
270 days.
I think on the ground of delay, I'll dismiss it and you go on. That's the best way of doing. You can't file a petition here delayed. You don't go and appear there in the court. You can't take advantage everywhere. Your honesty or bona fide could have been assessed and the benefit could have been given if you would have appeared in the trial court. You in the trial court, you are taking dates. Here you have filed a petition delayed by 250 days.
Let's say Your Lordship would see that the same thing as parallel. The reason why I couldn't file this petition, because I had submitted on the last date that he was ill and he is staying with his son in Bangalore. And there was communication gap. Even I said that I got the documents in installments. That's why I couldn't file even early.
So show me his medical thing.
Medical documents I do not have. If Your Lordship wishes that.
Ailing will not make you a 70. He's 70-year-old.
Yeah.
But show me some document that he was ailing. That is also not there.
He's with his son in Bangalore. I can get.
Maybe he's a son. But what are the charges?
Judge, it's basically a vigilance trap case, Your Lordship.
Then
the only thing, if Your Lordship.
7.
My Lord.
Section 7.
My Lord. Section 7. Your Lordship, at the time of cognizance, the only thing it is to be seen that whether this would culminate in any conviction or not. That's the only short point.
No, at the time of cognizance.
Discharge
at the time of cognizance, the court has to see prima facie.
My Lord, while adjudicating on a discharge petition, the question is that whether the charges, whether the evidence is present, will lead to conviction. I'll say only 2-3 sentences, Your Lordship. May kindly come, Your Lordship, may kindly come, page number 64.
64.
My Lord. Yeah. The charge is that he was caught red-handed with 2,000 rupees of bribery notes. Your Lordship, the second paragraph. Personal search of Dr. Suranath Jyotish was taken in presence of the witness, one mobile phone, along with some 440 rupees in a money purse was recovered, which was handed over to him. This is what was found from his possession. Your Lordship, second thing I would like to bring to my Lord's attention is that he was apprehended while he was page number 62, Your Lordship.
What is your name?
Dr. Jyotish. He is a doctor, medical doctor. My Lord, page number 62. Your Lordship, it's a middle of the page. There is this amount mentioned 1,000. If just above that, 2 lines above that, at the time of our arrival, Dr. Jyotishi was being ready to go out of his quarter. So while he was going out of his quarter, he was apprehended, and he was apprehended only with 440 rupees in his purse. Your Lordship, the third thing that Your Lordship may kindly take note of is that the entire question is about he issuing a medical certificate, antedating a medical certificate, which is actually not required. Because for a maternity leave, a medical certificate per se is not required, only the medical document should suffice. In this case, what has been seized, Your Lordship? A true photocopy of the said medical certificate duly certified by S.N. Joshi, supplied by Dr. Joshi on request, as original will be taken by the wife of the complainant to hand over school authority. Your Lordship, these are the issues involved. That's why I would pray that Your Lordship may kindly give me an opportunity to press it in detail. Discharge, at the time of discharge, if these kind of discrepancies are found.
See, the demand is there.
My lord,
and recovery is affected,
no,
and your film test is found to be positive,
my lord.
and
my lord,
then
the
all
discovery,
these things has to be thrust out.
my
in
lord, the
trial only.
discovery was not from me. That's what is my point. I was leaving the house.
Just come
My
to
court-
page 64, last paragraph.
My lord,
Following the trap. Ready.
page 64.
64 last.
After completion of the 64, your lordship,
64, following the trap. That paragraph.
following the trap. Yes. After hand wash, cotton swab was wash of table drawer. Your lordship, it was seized from
And if you put it in the table drawer,
My lord.
and from your pocket, how do you expect?
No, that's what
400 rupees recovered from your pocket.
that
You
is
have
what-
taken and put it in the drawer.
No, that is what is the issue, your lordship.
That is what the trial.
I was apprehended from the door while I was leaving the door, leaving my quarter. That is what is the point.
You might have kept it in the your hand was tasted.
Hand can be tainted.
And the presumption operates now
No.
against you. Once you accept the bribe,
No.
you have to explain it is rebuttable presumption.
No, your lordship, even the other questions.
Just read it further.
Yeah.
Read it further.
Table of drawer, seizure of the exhibits. That seizure is also
Seizure of the exhibits, tainted record
recovery
money,
note, medical
medical
fitness
fitness certificate,
the sheet,
receipt of the
sheet of
paper
paper
containing
containing
number of
season
GC notes
residential.
and residential quarter
Quarter
premises.
Dr. Surana
Dr.
Jyotisi.
So-and-so was searched in presence of the witnesses. A sum of rupees 5,000 so-and-so was recovered from the steel almirah of his bedroom and from the recovery of all these bills so-and-so.
That is what is the issue. The
Acceptance is there.
No, accept. That is the point, your lordship. Now, so the question is to be decided whether I took the money or it was kept in my drawer, because I didn't take.
Those things will be done.
My lord, second thing is the entire question which revolves around me issuing a certificate. That certificate is not an exhibit.
I don't think you have a case for discharge. Not a case for discharge. Once you accepted the money, it is under your position, in your table, you have accepted the hand in your hand. Then you have to explain it in the trial only. As simple as that.
All the questions will be put to the
You
complainant
put
at
it
the time of
and
trial, whether he himself received the money or not. So this is a trap case. So
It is a trap
this
case.
case, it cannot be from the detection report, it cannot be ascertained that
Detection report is the basis. Detection. My lord,
rupees, he is personal.
Wrong, right, whatever, but you are in trap.
yeah, that's the point. The trap has been said for whatever reason. The thing is, basic question on which the entire case is built up, that I accept.
What I do is, I'll on the ground of delay, I'll dismiss so that you will have an option of arguing that at the stage of trial, framing of formal charges. That's a better idea. Without influence, without getting influenced by the observation already made, you can very much. On the ground of delay, I'll dismiss it with that observation that you can argue those points once again. Isn't it? Right. Petitioner is believed by the order dated 6/12/2023, passed by the Special Judge Vigilance Sandarkar, rejecting his petition under section 239 CRPC for seeking discharge from the yes. The petition has been filed belatedly. Therefore, an application being IA number 1051 of 2024 has been filed, seeking condonation of delay. The challenge to the discharge application filed in the present petition is suffering a delay of 19. How much? 19? 200, how much?
278.
278. 246.
246.
246. The petitioner to explain the delay has in previous stated.
Yes, sir.
Has in previous stated on his application as under Para 3. Para 3. The explanations offered by the petitioner to explain the sufficient cause which prevented him to approach the court in time is not satisfactory. Therefore, I am not inclined to entertain this application. Hence, on the ground of delay, the present petition is turned down. At this stage, Mr. Mishra for the petition admits that since this court is not traversing into through the merits of the case, he may be given option of arguing the matter at the stage of framing of the charges, uninfluenced by the observation made by the court in the impugn order. The present petition is dismissed on the ground of delay. However, dismissal of the petition shall not preclude the petition right of the petitioner to urge all the points before the court below at the time of framing of formal charges. Yes. Dispose of. I have given you one more.
Okay, deeply.
Yes. No, there is only compromise. The hearing matter can't be taken up.
Only, I may be permitted to withdraw, but the petitioner number 1 is died. Flag 1 test certificate I have filed. The case has awaited against him. As far as the petitioner number 2 is concerned, my lord, I may be permitted to withdraw to raise all the issues at appropriate stage before the law trial.
Yes. Petition number 1 and the present has already
died on 21/6/2023.
Died on
21/6/2023. Death certificate is at flag 1.
Yes. Hence the present petition for him awaited. Insofar as the petition number 2 is concerned, and counsel for the petition has moved an memo to withdraw the same with reserving his right to urge all the points before the court below at appropriate stage. Appropriate stage. Dispose of it withdrawn with the liberty as well. Yes.
Item number 90.
92, my lord. On the quashing of FIR on the basis of factual aspect, and my lord, the matter has been settled in between. The informant has already been begotten a child, my lord, that is a female child. Last occasion, we are not able to produce the birth certificate. That is why the case has been adjourned, my lord.
They are married and they are
Both parties are present.
alive.
What are the offences? Boxo is there. How is it possible?
Informant and the accused all.
That's right. Informant appear. Boxo is there. That's the problem.
The POSCO Act is there, my lord, but the factual aspect is that, my lord, on
164.
Recording is not. Yes, diary.
Do you have anything? What is this says?
Stage, my lord, trial has not yet been started, my lord.
So give me the charge sheet. You must be having the charge sheet with you.
Charge sheet they were not annexed.
At least give the charge sheet. Let us know. The POXO is there. It's not routine thing. You must tell me what are the allegations.
To that effect, my lord, I have no instruction, my lord.
Why are you troubling your this lady and the child? There every time you are coming. Why are you filing the incomplete petitions? Must give me the POXO. I can't quash like this unless I know. There is a judgment. Otherwise, you are directly covered by my judgment. But there is a judgment now. Unless you distinguish the judgment on facts, I can't quash it. For the purpose of distinguishing that on facts, at least you should have material.
Kindly then posted for Monday, my lord, I'll be posting.
I will post, but I am looking at these people. Every day you are calling them. First you satisfy me, thereafter you call them. Don't call them like that.
Well,
since morning, the lady must be there in the court.
no, my lord, just in second half they come.
Why are you troubling them? I don't understand you. From Baleshwar she might have come. Don't call her next time.
My lord.
We sit 1 week to it. Yes.
I'm
not taking up interim order. Continue.
103.
Lordship will fix any date, not date. The lady is being deprived of a maintenance.
It is not like that way.
No.
Oh, that matter.
Yes,
It is not so simple like that.
I'm just saying.
In presence of both of you, any simple matter will be complicated.
My senior, not with me.
But by lords, it's whatever his submissions are have directly been negatived by the Guwahati High Court following the appeal project.
I'll give a short date then. I'll give a short.
My lord, I have got Supreme Court judgment which negatives Guwahati High Court judgment.
Okay.
Otherwise, he treats his own judgments. Go to
103.
Yes. 103?
My lord.
What do you want?
Can be disposed of.
Yes, so
It's appellant.
you are appealing? You are appealing?
No, I'm appellant.
Your lordship is delivered. And Supreme Court judgment, if your lordship, I'm not, sorry, I'm not.
Yes,
supposed to.
yes.
But your lordship judgment is rather more.
Now I have dealt with every aspect of it, but now
But the apex court judgment, sorry to say, my lord, your lordship can distinguish that judgment.
they only on the facts.
Yes.
So therefore, I need support on facts. At least everything should be filed so that I can write.
Your lordship judgment and the honorable judgment.
There was a small problem because of some misunderstanding. Mr. Ponda was appearing. We were relying upon a 164 statement to distinguish that.
But if
And distinguish also. But there was a little problem in communication here.
both the judgments at a time, I think my lord's judgment will prevail.
The same thing I did. I relying upon the Rosalind, which my judgment, I distinguished the other judgment and quashed it. Relying upon 164.
That fact was totally different. Rather, your lordship.
So the problem is
your lordship has vividly dealt all the aspects.
But the problem is the petitions are being filed without any fact, without any document. We have settled and bring entire family and make them parade here.
Distinction has to be made before.
Make them parade. It's so unfortunate that the women, children are coming and standing in the court. If you see the petition, there is nothing. Nothing is written except FIR, nothing.
Two judgments.
Bring the entire family and make them stand here.
With due respect,
Very, very unfortunate.
Two judgments at a time. I think my lord can easily say that your lordship's judgment is correct.
So somewhere I want to, if appropriate assistance is given, somewhere I want to distinguish that so that linear to the benefit of the other people. But that kind of assistance is required. I'll appoint sometime in some matter amicus curiae to just remind me. I'll appoint Mr. Bose as an amicus curiae. So he will, at least he has done it. Distinguish it so that it will be anywhere to the benefit of others.
My matter is, can I give a memo so that if it comes, I can argue that will follow in order.
Give that memo.
I'll give that memo to
take it. You give that memo. At least I'll hear that matter.
Yes.
If that matter is disposed of for the other thing.
Well, I'll give memo tomorrow.
Please give the memo. Please give. Is 103, na?
Hello.
103. Yes, madam.
Hello.
That's item 93. Item 93. It can be disposed of. A bank.
Everything can be disposed of.
Disposed of your lords may fix up a date on Monday.
No, it can be disposed of. It's a small matter.
Yes, small matter.
What is this?
Misappropriated the bank as an employee, misappropriated the amount. Later on, they deposited. Bank appeared your lords, personal to your lordship direction. Lordship has last time said you may add them parties and after the bank will come, I will.
1 minute. Bank is there,
huh? Case 17, it has been stated that they have misappropriated rupees 15 lakhs some odd. And later on they deposited in the union.
They misappropriated from where?
From the bank, Paradipgarh branch.
Whose money?
Money is bank money.
Who is
they are the employees.
Who is opposite party number 2?
OP number 2 is the bank.
No.
Manager.
Anand Kumar Sharma.
No. Let's be
90. Item number?
97.
93 you say. 97.
97, 98.
97, huh?
Lordship 97.
Branch manager, Union of India.
Union of India, manager.
Union Bank of India. You don't have any problem.
But there is a criminal attitude, my lordship, because this person, there are two persons, my lordship, and they have misappropriated of 14 lakhs for 86,760, my lordship. They are the.
Now, what is the modus operandi?
It is not.
How they have done it? No, deposit is all right, but how?
Deposited, but
Last again, your lordship has
offense,
stated.
my lordship, under section 408, 409, and 35.
No. What is the modus operandi they have adopted to misappropriate?
Case ready.
Fine. 2-3 days back, I have given a judgment. Read para 16. You may get some benefit.
Recent judgment. Yes. Last again, your lordship has stated that criminal.
I gave a judgment 2-3 days
Yes.
back. Just see para 16 of that judgment. Okay. Then I'll put next to the question.
Item.
Read it and come. That judgment. Okay.
Item 95 ta compromise.
Judgment.
Yes,
Please. Para 16 of that judgment. Yes. Yes.
Item 95 ta compromise matter ta on
95.
consent of senior advocate Sri Dhala can be posted to 24 your lordship. He has advised me. Yes. Item 91 and 95. 91. Can you take now any other date?
91?
Can you take now any other date?
I didn't follow you.
You listed only any other date, my lord.
Oh, it will be listed, obviously. Yes.
My lord, item number 98, my lord.
98.
98, your lordship. Despite sufficient service with the notice on opposite party number 2, no one appeared, my lord. I am taking fresh step for OP number 2.
What are the offences?
My lord, here your lordship, they initiate a complaint case, my lord.
Complaint case. Then you take fresh step.
Fresh step.
Okay, fresh step.
My lord.
Take.
Interim order is there, your
Interim
lordship.
order to continue.
Grateful, your lordship.
Item 82, the cover judgment, I have marked the receivable fund.
As you have given that,
Yes, sir.
82. ठीक है ना? Paragraph लिख दो. Yes. ठीक है. जो तो मार्क क्वेश्चन का उतार दो. Report head करते. Okay. Thank you.